the public, and then we will vote on each bill.
Thank you.
So the chair lays out SB 9, SB 1047, SB 40, SJR 1, and SJR 5, and recognizes Senator Huffman to explain the bills and committee substitutes that she has for SB 9 and SJR 1.
All right. Thank you, Mr. Chairman and members, and welcome to the public and all the interested folks who are here today. As we all know, this is an extremely important legislation that you have before you today. So I will lay out the bills and happy to answer any question. I'm going to start with SJR 1. Members and public, it is undeniable that our state has experienced a significant increase in illegal immigration in recent years. Unfortunately, this surge has also led to cases where illegal immigrants have committed serious crimes against Texas residents with insufficient mechanisms in place to detain those who pose a considerable flight risk. Recently, President Trump signed the Laken-Riley Act, directing the United States Attorney General to take custody of any illegal alien charged, arrested, convicted, or who admits to committing certain criminal offenses. To support the federal government in implementing this law, Texas must establish comparable detention measures for illegal aliens accused of felony offenses. Specifically, SJR 1, if approved by the Texas voters, again, the voters will have a say on this, would amend Article 1, Section 11 of our state constitution to require the denial of bail for an illegal alien as defined by the resolution who is accused of a felony offense upon finding a probable cause. The definition of an illegal alien in the resolution aligns with the federal definition of an undocumented criminal alien. Finally, it is important to note that the judge or magistrate setting bail must first determine that probable cause exists to believe that the person engaged in the conduct constituting the felony offense. Members, I do have a committee substitute because this is a very special bill, and although this is difficult, the committee substitute to SJR 1, because it adds this to the act, shall be known as Jocelyn's Law. On the night of June 16, 2024, Jocelyn Nungare was sexually assaulted and murdered by two illegal aliens from Venezuela. These two men entered the country illegally and were even apprehended near El Paso by Border Patrol and subsequently released. They were released with a notice to appear in court. To make matters worse, these two men were not denied bail, even with the preponderance of evidence that existed at arraignment and the fact that their illegal alien status presented that no one can argue was a major flight risk. If these men had the financial means, they could have been out on the streets today, and that is unacceptable in the state of Texas. I'd like to thank the Lieutenant Governor who has joined us today and Jocelyn's family who is here for working with me to name this joint resolution after this beautiful girl who was taken way too soon. I appreciate her family having the strength and the courage to be with us today, and I know that they continue to advocate for this wrong to be righted, and we can do this, members. SJR 1 shows the state's commitment to protect our citizens and assist the federal government in their efforts to prevent violent illegal aliens from terrorizing our communities. And that is the layout for the committee substitute to SJR 1.
Members, are there any questions of Senator Huffman on committee substitute for SJR 1?
I don't have any questions.
Senator Hinojosa, you recognize.
Thank you, Mr. Chairman. I guess I'm trying to get the bill straight, Senator Huffman.
Of course, I'll answer any questions
So
I can for you.
We are on SGR 1,
Yes, SJR 1. That's the bail denial for illegal aliens.
and you had a substitute.
Just to name it Jocelyn's Law
Okay.
for the
got it.
name. Yes,
So
that's the only change in the legality. There's no change in the other issue.
And actually, quite frankly, we've had situations. Oh, can we ask questions now, Mr. Chairman?
Yeah, of the committee substitute. If you have any questions about the committee substitute.
I do not.
Okay. Would you like me to move on to the next one, or is
We'll move adoption of the committee
Okay.
substitute. So members, Senator Parker moves adoption of the committee substitute for SJR 1. Is there objection? Hearing none, the committee substitute is adopted for discussion. You may proceed.
okay? Then I will move on then to SJR 5 members, SJR 5, and do my layout. SJR 5 is similar to multiple iterations which passed the Senate with bipartisan support in 2021 and 2023, including a vote of 30-1 on SJR 44 in 2023. And I see my House sponsor, Chairman Spiller, is here. Thank you for being here and showing support. I appreciate it. Thank you. Since we started this journey back in January of 2021, there has been at least 162 homicide cases filed in Harris County for defendants released on one or more bonds at the time of a new murder offense. So take that stat and think about it. 162 innocent lives lost just in Harris County alone. I'm sure that the stats would be higher if we had data for the rest of the state, but we don't. Crime Stoppers in Houston has done a great job of Andy Kahn and working and keeping track of these statistics, and therefore we're able to offer the members hard data on what the result of not enacting this legislation earlier has actually cost to the lives of Texans. It has become starkly clear that our local officials making bail determinations day in and day out need this tool to protect the people of Texas. SJR 5, if approved by the Texas voters, again, the voters get a vote on this. The public, the people of Texas can tell us if they want this, and I'm betting that they're going to overwhelmingly want this. It would amend Article 1 of our state constitution to expand the options available to officials setting bail to include the denial of bail under certain exceptional circumstances. It would expand the potential denial of bail to include persons accused of committing a sexual offense punishable as a felony of the first degree. So those are the most violent sexual assaults where a weapon was used or there was serious bodily injury inflicted. A violent offense is defined by the Constitution or of continuous trafficking of persons. However, for bail to be denied for one of these offenses, and these are the safeguards, the constitutional safeguards in place, a judge or magistrate must determine by clear and convincing evidence that the denial of bail is necessary to ensure either the safety of the community, law enforcement, or the victim of the alleged offense. Furthermore, a judge or magistrate who denies bail under this provision would have to issue a written order laying out their findings of fact and explaining why the denial of bail is necessary. Even in the federal court system, denial of bail is often utilized for a range of offenses. This isn't new territory here. This happens throughout the nation. Unfortunately, we have been unable to get this important tool over the finish line in the last several years, and innocent lives have been lost as a result. And the data will be presented today to show you that. This has only delayed the ability of our judges and magistrates to utilize a tool that is unbiased to a defendant's ability to pay and will meaningfully enhance public safety. I am thankful, and I'm very thankful, for the letters of support from the mayor of Houston, John Whitmire, who, when he was chair of this committee, supported this legislation, and newly elected Harris County District Attorney Sean Tier to show that this is truly a bipartisan effort, and it is for the citizens of Texas. I would like to thank Governor Abbott for adding this bail crisis as an emergency item, and of course the Lieutenant Governor for always being a champion on this issue. I'm confident that the Senate will continue to deliver on this critical matter. I'm hoping for a unanimous Senate this time. I'm going to work on that real hard to see if I can get that one more vote. But the House, and I'm, with all due respect, Chairman Spiller, must act. Please, please pay attention to this, and I would urge you, if you're listening, to contact your House members and tell them how important this is to everyone and to the safety of Texans. And we want to get this, of course, on the ballot by November. The people of Texas deserve this. They're calling for it. And with this legislation, we could make a step forward for protecting our citizens. That's my layout.
Thank you. Any questions?
I do want to point out that we passed this exact bill up 3 times out of the Senate.
Yes.
It died in the House.
Yes.
That's where the obstacle has been.
Yeah. And I'll say it publicly. There's a handful of Democrats, most from Harris County, who were the block. So if anyone wants a list, I have a list of the names. Don't want to go there, but I will, because it's time to make this happen, and we're going to play hardball this time. All right.
So Senator Huffman sends up the committee substitute for SB 9 and is recognized to explain the differences between the committee substitute and the bill as filed.
Okay. All right, laying out SB 9. Members, in 2021, the legislature passed Senate Bill 6, which was legislation I sponsored, which addressed the release practices for habitual and violent offenders to better protect the safety of victims, law enforcement, and our communities. SB 6 represented one of the largest overhauls to Texas's bail system, drastically increasing the amount of information available to judges when setting bail and enabling statewide data to be tracked on bail outcomes. Although we've made great strides, more must be done to ensure that judges and prosecutors have the tools they need to protect public safety. Again, we were able to write this bill based a lot on the data that was collected by victims advocates, help from the DA's office, and I'd be remiss not to recognize former Harris County DA Kim Ogg, who's also been a champion on this and helped us so much over the years. And I think it says a lot about you that you're sitting here today. So thank you very much for being here, Kim. Appreciate it. Senate Bill 9 includes several different policies to further strengthen our bail system. First, it requires hearing officers to make oral or written findings of fact and conclusions of law on the record at the time they issue a no probable cause finding. So, members, we were discovering that there were some judges who just, for no reason, the prosecutors couldn't figure out why, because they felt like they had presented probable cause, would just make a finding no probable cause and the case would just go away. This was happening on enough occasions that it came to the attention of myself and others who wanted to make that. If a judge wants to make that decision, they have the discretion to do so, but they have to say why they're doing it and put that in writing. This protects the public. Second, the bill mandates that the presiding judge, rather than a criminal law hearing officer, be the proper authority for setting the initial bond for a defendant on parole at the time he or she is charged with a new offense, a defendant who has been previously convicted of 2 or more felony offenses, a defendant charged with certain violent felony offenses such as murder, capital murder, aggravated kidnapping, and assault, and a defendant charged with a felony who is also detained with a concurrent immigration hold. This change ensures that the most important bail decisions are made by judges who are elected officials and should be held accountable by their constituents. To build on past efforts, the bill also amends the list of offenses that a defendant may not be released on a personal bond. As you remember, we added a large list when we passed this in 2019. So we add unlawful possession of a firearm by a felon, violation of a family violence protective order, terroristic threat, and murder as a result of manufacturing or delivery of fentanyl. Again, these were over time episodes and anecdotally, and the prosecutors came to me, not just Harris County, saying that these needed to be added to the list to further protect the public. Additionally, the bill adjusts the reporting requirement for charitable bail organizations to be sent to the Office of Court Administration and increases transparency of these organizations by requiring additional data submissions. SB 9 also establishes that a bond for a jailable felony offense may not be set until the defendant has gone before a hearing officer or a judge, and it creates a new avenue for appeal. When a prosecutor considers the bail amount insufficient to preserve public safety when a defendant is charged with a felony and has previously been granted bail for a separate felony offense, it allows the prosecutors to appeal. Lastly, for a secondary offense committed in a different county under Texas Code of Criminal Procedure Article 17.027, the bill clarifies that the county of the previous offense must be notified of the new offense within the next business day. Therefore, judges can know if someone out on their bond is committing offenses in other parts of the state. And I do have a committee substitute, and I know you've laid it out. It's very simple. It just adds in language from SB 1047, which will be the next bill that I lay out. It just makes adjustments to the new information that will be included in the public safety report system, ensuring that we have the technical capabilities to provide the information, and it gives the Office of Court Administration sole discretion to modify the public safety report system to incorporate technological advances that promote public safety. It also provides additional clarification to the section of ex parte clear in a district judge's jurisdiction to modify a pending bond set by a lower level magistrate. Finally, it adjusts the no probable cause finding of fact process to better take into account venues that are not courts of record. And I will say, members, that we have worked with different size courts and counties around the state, whether it's JPs or magistrates and so forth, to try to make this bill work. We understand it's a big state and there's kind of different situations about how all these procedures occur. And we have worked closely with the Office of Court Administration, and I, through the budget process, I'm making sure that the funding's there for everybody who needs, these technological help and so forth to make this actually work. So it's a work, so to get it all done. So, members, while there has been many improvements to the bail system, there's still a lot of work to be done. We read day after day, story after story of the atrocities that are occurring. It's almost unbelievable, actually, when you start looking at what is happening. Violent, repeat offenders continually being released on low bail to only recommit in our communities. It's not one or two occurrences, there's hundreds. And every story, every family is tragic. And it's something that should not happen, should not have happened. And I usually don't say this because I know that a lot of circumstances occur with crime, but I truly believe that there are hundreds of people dead today that would not be dead if we had incorporated some of this legislation earlier on. And that's a sad statement to our state. It is. It's sad. People deserve better than this, and we should give it to them. We owe it to our constituents to right this wrong. I want to remind everyone, this bill is a pointed effort focused on our violent repeat offenders to do just that. It does not alter the bond practices surrounding lower level misdemeanors. I want to thank again the governor and the lieutenant governor for continuing to make this a priority issue, and my Senate colleagues who have been so supportive through this long process.
Senator Huffman sends up committee substitute for Senate Bill 9. Members, are there any questions of Senator Huffman regarding this committee substitute? Any questions? Members, Senator King moves adoption of committee substitute to Senate Bill 9. Is there objection? Hearing none, the committee substitute is adopted for discussion. May proceed on the next bill.
That would be SB 1047.
1047.
Yes, I sort of laid out, it's really just a technical cleanup. I've done it as a standalone bill. I'll ask us to leave this pending in case everything else falls apart. It would be nice to have a vehicle to help with the technical issues that the OCA and DPS need to make even the current law work.
Thank you. Any questions, members? May proceed to Senate Bill 40.
Okay, SB 40 kind of adds insult to injury, I'm going to put it that way. As we've dug into all of these bail issues deeper and deeper, we heard some reports that Harris County is spending public funds to pay a nonprofit whose posted goal is paying a defendant's bail bond. After reviewing the Harris County Auditor's website, my office has determined that since February of 2022, Harris County has issued at least 311 payments for a total of nearly $2.1 million to the Bail Project, which is a nonprofit organization that offers bail assistance at no cost. This use of taxpayer dollars includes at least 48 payments of over $10,000, with an average payment amount to the nonprofit of $6,707. So again, these are going to be felony offenses. This practice raises serious public safety concern as it allows defendants to be released from jail using the same source of taxpayer dollars that were used to arrest and process the offender. The bill seeks to address these concerns by prohibiting the use of public funds by a political subdivision to pay a nonprofit organization that accepts and uses donation from the public to deposit money with a court in the amount of a defendant's bail bond. The bill also creates a pathway for a taxpayer or resident of the political subdivision to seek injunctive relief to prevent further action by a political subdivision that violates these restrictions. A taxpayer or resident who prevails in this action is entitled to recovery from the political subdivision, the taxpayers or residents' reasonable attorney's fees and costs incurred. We don't know how long this practice has been occurring, but we have discovered it now, and I think we need to put an end to using taxpayers' money to bail out criminals.
Any questions, members?
That's it. That's all the layouts.
Thank you, Madam Chair. The chair now opens testimony from invited witnesses on committee substitute for Senate Bill 9, Senate Bill 1047, Senate Bill 40, committee substitute for Senate Joint Resolution 1, and Senate Joint Resolution 5. So the chair calls the following witnesses. So as you come forward, please identify yourself for the record and speak into the microphone. If you have written testimony, please submit the copies to our committee staff at the desk to the right. So if Alexis Nungary, Jessica Gehring, April Aguirre, and Paul Castro, if you'll come forward. So Alexis Nungary, Jessica Gehring, April Aguirre, and Paul Castro. So is Jessica Gehring not here? Not yet. Nancy Bola, come forward. Thank you all for being here, and we'll begin with Ms. Nungary.
Having me here. My name's Alexis Nungary, and I'm here to provide my testimony. I'm here and I feel outraged that the Texas judges are allowed to provide bail for evil people who do heinous things. My daughter's life was taken away 6 days shy of 8 months ago, and they didn't give her any type of mercy. I was in the process of planning my daughter's funeral while I had to take a pause to go to court on separate occasions for both individuals to make sure that they got an adequate bond. And I feel like it was a slap in the face to Jocelyn and our family to even have to make sure that they got an adequate bond, because they preyed on her innocence, and they had no business being here in the first place. And the fact that I had to even go and endure that with my family to make sure that some sort of bond was applied to them, they shouldn't have even had the option nor the choice to. They didn't give Jocelyn a choice to live another day. And it's very upsetting to know that I had to sit through that, and they are a flight risk, and they should have had no opportunity to been provided a bond in the first place. They didn't belong here, and I'm here to fight for her and her voice and make sure that any illegal immigrants who come here will be rejected bond, because they don't deserve that in the first place. Thank you for your time.
Thank you very much for being here, and you've been very brave throughout this and vocal and being a voice for your daughter. I don't think a mother could do anything better. So.
Thank you so much.
Senator Parker.
Can't thank you enough for being here, and please know that our thoughts and prayers are with you and your family, and we will do this to make sure that this never happens again to another precious baby girl. And thank you for being here.
Thank you for having me.
Your courage and your strength, and we'll get this right under Senator Huffman's leadership, and make sure this never happens again in this great state. Thank you. God bless you.
Thank you.
I just want to say from the chair, our deepest condolences. We want to do everything we can to make sure that in Texas that we have swift justice and justice for all, and to be as proactive as we can instead of trying to be reactive, to be able to prevent this into the future. And then thank you to Lieutenant Governor and Sheriff Huffman for their leadership in this. But we shouldn't have to have you come to the legislature and talk about this and the failures of the system to protect Texans from crime. So thank you for being here. Thank you for giving us the knowledge and share your sad experience, so that we as a legislative body will make sure that we do everything we can to protect the rule of law and to keep Texans safe. Thank you very much for being here.
Thank you.
So, Ms. Aguirre.
Hello, my name is April Aguirre. I am the aunt of Arlene Alvarez. She was 9 years old when she was killed on her way to dinner, within arm's reach of her mother and father and next to her brothers and sisters. I am saddened that we have to be here, but if we do nothing, nothing happens. Unfortunately, there has been a shift in our criminal justice system that because you're a minority or you are low income, you get special privilege. That is wrong because the majority of victims of crime are also minorities and are also low income. The day Arlene was killed, we didn't have enough money for a funeral, not even a cremation. But the person that put a bullet through her head was out on bail before you knew it. We couldn't understand why. We had to take a crash course in this criminal justice system and found out very soon that there's so many things in play for criminals, and we have lost sight of why we have a criminal justice system. We have a criminal justice system so that we don't have anarchy. We have to trust our government to basically make a wrong right. But what is that right? A right, well, all we want is for the individuals that harm our children and innocent crime victims to not continue to live their life as if nothing happened. I applaud all of you because these things are necessary. There's too much out there to help criminals and not enough for crime victims. I have passed out to you 16 pages of public taxpayer money that is going to the Bell Project. And excuse the way it's stapled, but if you start at the back, the last payment that they just received was on 2/5/25 for $14,950. And since 2022, and this is all public record in the auditor's office, since 2/10 of 22, they have received over $960,000. But as our family, we still have a payment plan for Arlene's funeral because we refuse to just put her in the ground in whatever casket. $78,000 is what that funeral cost because we don't want to put a 9-year-old little girl in whatever casket in a whatever plot. So I urge you that this legislation is important. So now the real question is, who did they bail out? Did those people go on to commit further crimes? Our police officers are doing their job, but there's agencies that are helping these individuals. Now, if you're going to help them on your own private dime, great. But for our taxpayer money to be going towards something like this is absurd. I can't understand it. But how much of the money that is accrued from taxpayers is going to crime victims? We have to pay for everything on our own. There's misaligned sympathies, but this is wrong. Taxpayers didn't sign up for this. 16 pages back and forth of money going to the Bell Project. And they've already made a statement against this bail reform on their website. I urge you to go to thebellproject.com to see what they're funding. And if it's happening in Harris County, it's happening across Texas, and it's absurd. As crime victims, we need help from our legislature. So I applaud you for helping us because there's enemies, there's giants that we can't fight alone. And for our government, our local government to be funding these types of projects that are completely against incarceration is absurd. So please help Harris County and Texas. Thank you.
Again, on behalf of the chair and on behalf of all of us, I'm sorry for your loss. Oftentimes, we see that in the scales of justice, it's tilted and forget about the victims. We've not forgot about the victims. And the scale of justice in our Constitution that everyone has the right to life, liberty, and the pursuit of happiness, and justice for all. That means justice for all. So thank you very much for your testimony.
Thank you.
Mr. Castro, Paul Castro.
Thank you. Thank you, Chair Flores. Thank you, Senator Huffman. My name is Paul Castro. I'm I ask for your support of Senate Bill 9 and SJR 5 to address problems victims like me face under the current bail bond system. My son David was murdered in a roadway shooting in Houston on July 6, 2021. He was 17. He should be celebrating his 21st birthday Friday. Instead, I'm here before you. That night, a two-time felon who was out on parole at the time chased me and my sons for 3 miles, shot at us from behind, hit David in the head, and killed him. A month later, As I was driving to see my surviving son, Luke, play for Westside High School's band, the same band that David should have been playing for that night as a senior, the phone rang. Caller ID said Texas Vine, the victim information and notification system. A robotic voice greeted me. Hello, this is the Texas Vine Network calling to inform you that Gerald Wayne Williams has been released from custody today on a bail bond. Williams somehow met the $350,000 bond just a month after his arrest. The judge had set a high dollar amount hoping to keep him in jail, but he failed. After Williams was first arrested, the prosecutor explained that a process could be used to request the court deny bond. She said in order to do that, we would have to present our case, but the court might need me and my surviving son to testify. That process would be repeated every 60 days until trial. With the backlog in Harris County, that 60-day cycle could repeat for 5 years. We decided not to pay that price. Williams was released on a discount bail bond a month later, precipitating that horrible call. After his release, our safety was left to Williams's ankle monitor. We later discovered Williams violated his bond restrictions, but because of the messed up system, we didn't find out until 3 weeks after it happened. Even though he did that, he did not get sent back to jail. He remained free. The current bail bond system allowed David's killer to smoke and drink with friends at home for a year after killing my son. David should be a college junior today. Instead, we mourn him. The community and the world are missing out on what he could have done. Our current bail bond system rewards violent offenders with freedom while cursing victims' families with fear and worry. We're left to hope that a system that repeatedly fails to protect us, one that places criminals' rights over those of victims, will keep our community safe. Ask the family of Martha Medina how that worked out. She was the 71-year-old grandmother who was murdered by Anthony Williams outside of a McDonald's in 2021. Williams was out on bail at the time he killed her on a capital murder bail bond because a lenient judge showed mercy for him and not for our community. Our bail bond system is broken. I ask you to support these bills. Thank you.
Thank you for being here, Paul. You make a critical point, and that is we are failing you. And we are. I'll admit it, we are failing you. We have to do better, members. We have to do better.
Senator Parker.
Thank you, Mr. Chairman. I just want to thank you for being here. I want to thank Mr. Gary as well for being here, and of course, Ms. Nungary. Because of your strength and because of your courage, we're going to make a huge difference. And under Senator Huffman's leadership, Lieutenant Governor's leadership, the Chairman's leadership here, bringing this bill forward to the committee, because of your insight, the fact that you're providing this information to us, exposing this darkness. Mr. Gary, you commented a moment ago, you called it misaligned sympathies. And you could not have been more accurate. That's what this is. And it's an absolute embarrassment to the state of Texas. It's disgusting. It should never have occurred. And again, when we take action on this incredible package of legislation that will protect lives, it'll be in the honor of each of your loved ones. Thank you all for being here, and thank you for your strength and continuing to relive this horrible tragedy that each of you have experienced in order to do the right thing for the people of this state and the greater good. Thank you all for all you're doing.
Mr. Castro, my condolences and thank you for being here with us and sharing your experience, as tragic as it is, so that we can work with you to create good policy for Texas, and so that we can work to make sure that we just prevent this from happening again. Thank you.
Chairman?
You're recognized.
Thank you. And I also just want to, y'all are a real inspiration to me for coming here today. I know how hard it is to testify. You know, we didn't need this 20 years ago. We've had I was thinking as I was sitting here, how in the Bible it talks about in Proverbs about that you don't show partiality to the rich or to the poor, and your comments on the fact that there's been this misalignment that all of a sudden because someone is a minority or someone is poor, that all of a sudden there's been some special setting in this. The reason we didn't need this 20 years ago is because we had a better judiciary. And this reflects the tremendous failure and breakdown in our criminal judiciary system, where we have judges and magistrates, and I was a magistrate for a while, and had these guys come before you and ladies every day on crime. And it's not hard to make the right decision at all. It is not hard at all. And if you have doubts, you always want to err on the side of public safety. And so it's frustrating to me that we have a broken bail system, but the real reason we have a broken bail system is because we have judges in criminal courts and magistrates in those settings who are not doing their job, and they need to be removed from office. And I just want to thank you for being here. It's 20 years ago, this didn't have to happen, but it's a reflection of our judiciary, particularly in Harris County, but really all across the state, there's problems. And that has got to be addressed, and I know Chair Huffman has worked really hard to try to do that. Thank you. Thank you, Chair.
If I could respond?
Senator Huffman.
Just to your point, a great point, Senator King, and I do want to say that I do have a judicial reform bill that is tied to the judicial pay raise, by the way, that would include a judge who repeatedly violated, these, didn't follow their instructions for all the different bail laws that are instituted, that would be subject for, removal and so forth. So there will be a way to actually complain about judges who aren't following the bail laws. Yeah, so we're balancing that. Anyway, thank you for pointing that out. Thank you, Mr. Chair.
Ms. Buller, you're recognized.
My name is Nancy Bulla, a mother who knows firsthand the devastating consequences of a justice system that fails to hold offenders accountable. My daughter, Indigo Garza, was murdered on February 23, 2022, a loss that no parent should ever have to endure. Indigo was raised in a loving home in Magnolia, just north of Houston. She was full of compassion, always willing to help others, and deeply rooted in her faith. But like many young people, she made mistakes. At 17, she lived with her father, where she became involved with the wrong crowd. A single bad relationship led her down a dangerous path of crime and drug abuse. Eventually, she was arrested for unlawful weapon possession. She was sentenced to 27 days in jail, but instead of serving her full sentence, a chance that might have forced her to sober up and turn her life around, she was released just after 9 days. 9 days, not even 2 weeks. The system that was meant to correct and protect her sent her right back into the world that was destroying her. This is why SB 40 is so critical. SB 40 prevents taxpayer dollars from funding bailouts for criminals. The idea that public funds are being used to release repeat offenders is an insult to victims and their families. Criminals should be held accountable, not given an easy way out of the community's expense. I urge you to pass SB 40, restored to public faith in the justice system and taxpayer bill-funded projects. Do this not just for Indigo, but for every family who has lost a loved one because the system failed to do its job. Let's ensure that justice means something again. This is my first time here before you, and I sincerely thank you for taking the time to hear our story. I appreciate the opportunity to share my daughter's journey and the concerns I have about our justice system.
Members, any questions? I'm very sorry for your loss, and thank you for sharing your experiences with us so we can work on good policy. Thank you very much.
Thank you for being here.
Thank you for being here.
Thank you.
Thank you for all of you.
Thank you. Ms. Jessica Daring? Ms. Jessica Daring? Okay, so we'll move on. The chair calls the meeting Kim Ogg, Jennifer Tharp, and Brett Lyon. So we'll start on my right, with Ms. Ogg. Welcome.
Thank you, Mr. Chairman. Thank all of you senators for your time this morning, especially for the leadership of Senator Huffman. Thank you to the Lieutenant Governor for showing the importance of this bill to the public by his presence. Chapter 56 of the Code of Criminal Procedure guarantees crime victims certain rights. The problem is there's no real relief or remedy if those rights are violated. One of those critical rights is to ensure that a judge considers public safety when setting bail. Now, it refers to judge, but in Harris County, we have a system of hearing officers and magistrates, unelected, unlike their counterparts in the judiciary. I'm here to urge and remind this body that crime is not a partisan issue, that criminals don't care which primary their victims voted in. And likewise, their safety, the safety of their victims, should not be determined through partisan politics. So I appreciate the committee's consideration of my testimony as the former district attorney of Harris County, but with 8 years of front row experience watching a change in our bail system. I want to thank you all for filing these bills, Senator Huffman, which are actually a reform of bail reform. Bail reform was sold to this country and this state and the prosecutors as something that would impact misdemeanor offenders who are low risk. Instead, we've seen it applied across the board, all the way up to our most serious crimes, capital murders. These bills go the distance in requiring greater transparency of our magistrates who are not elected and therefore not accountable to the public. It also requires judges to hear an expanded array of cases that were formerly allowed to be heard by magistrates when considering bail. That is the responsibility of our elected judiciary so that they can be accountable to the public, not the responsibility of magistrates appointed by those judges and often utilized to set bond in difficult cases, high-profile cases specifically. The courts have allowed themselves to also utilize a process called probable cause. Now, our magistrates are there to ensure that probable cause exists when the district attorney files a charge. We've made a preliminary review in Harris County, working with the police officer, and we see over the last 7 years, specifically since 2019 and the election of a different judiciary in Harris County, we have seen thousands of cases dismissed by magistrates and judges for no probable cause. That number was steady at just a few thousand up until 2019, and it exploded in 2019 and has only gotten larger. The problem with finding no probable cause is that the case goes into limbo and really forces the district attorney's office to dismiss these cases. The victims are not notified unless we're able to notify them. Police have no idea what they have done incorrectly in their presentation. Prosecutors don't know. And judges and magistrates, the hearing officers in Harris County, have in large part refused to state in writing or verbally what's wrong with cases being presented, therefore blocking any credible attempt to improve the cases so that the offender in custody can go ahead and be processed, and resulting in thousands and thousands of wasted staff hours by both police and prosecutors. These bills go a long way in holding our magistrates more accountable and making judges responsible for bail, which is their statutory responsibility. The failure to notify victims, can you imagine being the neighbor who calls somebody in, a judge finds no probable cause even though a policeman has arrested the person, and he's back home before you go to work? It's insult upon injury, and it's dangerous. With regard to the bill that would require judges to hold illegal, undocumented immigrants who commit felonies without bail, this must be passed. Jocelyn's case is not the only tragedy and not the only horrible crime committed by illegal immigrants. Corporal Charles Galloway was gunned down by a Salvadorian on a routine traffic stop. He never even had the chance to undo his safety belt, much less pull his service revolver before he was gunned down by somebody who appeared to have military training, got out of the car and shot him 17 times into his car, small pattern. These individuals, unless we can immediately charge capital murder, these individuals must have bail set by judges. We applaud you in giving the judges more authority and reason to hold these individuals without bond. In Ms. Nungare's case, the holdup was the lab. To prove sexual assault, to establish probable cause, we needed results from lab tests. Our labs in Houston are backed up horribly, and so it took months. And while the bonds were set at $10 million, it really caused the Nungare family a great deal of anxiety to know that it was possible for someone like the Bail Project or any group of individuals with misguided empathy to actually post the bail. It didn't happen. We were able to file capital murder, but would like to spare our crime victims that indignity. So in pursuing a level playing field for our crime victims, I'm here to express my support to each of you, to urge my Democratic colleagues who serve in our House to understand that it's their neighbors, it's their friends, it's their family members who are actually being impacted by the high-risk system that we have in Harris County, not transparent and in need of great reform. Thank you all for your time this morning.
Members, any questions? Senator Hinojosa, you recognize.
Thank you, Madam Chair, and good seeing you again.
Thank you, Senator.
One of the things that sometimes the public may not be aware of, that we have pretty much lost control of the border and as it relates to the number of immigrants coming across. Probably less than 50% are families looking for work. And what they do is they end up pulling the Border Patrol off the borderline, if you will, to help them process for asylum or whatever they're asking for in terms of help. But over 50% of the people that are coming across are males. And those males, from the information that we have, can you hear me?
Yes, sir.
Are in that group. You have a lot of cartel people. You have a lot of gang members. You have a lot of people with criminal records. Some who've been charged with a crime here in the U.S. and going back to Mexico. And those are the people that really seem to be getting through the holes that we have and the loopholes we have in our system. One of the things that happens, I don't know the practice in Harris County for whether you have a standing order that no person who is here illegally or undocumented cannot have a bond. And you know, when you have the standing order, many of the judges still provide for a bond and don't wait for a retainer from the Border Patrol. So what has been your experience in Harris County as it relates to, and this bill, the one we're talking about, SCR 1, only pertains to felony charges.
Sir, what we have seen in Harris County is a complete disregard for the potential for flight risk, especially when it comes to illegal, undocumented aliens. We also lack any history, criminal or otherwise, on the individuals captured at the border who've already committed an offense by entering our country illegally, and they're being released with no information about their background, especially when they come from countries with no diplomatic relations with the United States, such as Venezuela. That happened in the Nungare case. Individuals who very well may have criminal past, released after being captured. They come to Houston for a variety of reasons, work, easy access to victims, criminal networks that are in place and farming these folks out across the country. So the need for a not just a policy, but a law that would require judges to hold these individuals at no bail should be passed. And the remedy to how we keep them from filling up our jails continuously are faster trials, which again come back to the responsibilities of the judiciary. In Judge Huffman's day and my day as a line prosecutor, we saw these cases tried within 18 months. Now we see 3, 4, 5, 6 years pass, often with these same individuals out on bond, and they flee. It happens continuously. This is not just true for murder, but you have a bill that would expand the ability to hold people charged with human trafficking at a certain level and sexual assault also without bail. We see this constantly where very dangerous people with no ties to our country are released on insufficient bail. I also want to thank this committee for considering the opportunity for the state to appeal these cases. We pioneered that practice in Harris County. We did it successfully at the Court of Criminal Appeals, but you can't go to that well over and over. We need a law that requires it, not an exception that we have to go fight for on only the worst of the worst cases, when actually the public is exposed to great danger by thousands of criminals each day in Harris County who are from other places who we have no information on.
It happens in the regions of the state. One more question, and that is, in Hidalgo County, we have a standing order, so to speak, that if you are in this country legally or undocumented, they hold you because there'll be a retainer placed by Border Patrol. But one of the challenges that we still face is the magistrates. As you said a while ago, they're not the real judges. And many of them are untrained and are not held accountable because they will set a bond for someone who is being charged with a felony, for example, drug smuggling or human trafficking, and they'll set a large bond, but for the trafficker, it's not a big deal. They'll put up $250,000, $500,000, and then next day they'll be in Mexico. I mean, it is a real issue that we need to address on the magistrates and have the judges who actually should be the ones responsible for setting the bond be accountable to the public. But thank you for your testimony.
Thank you, Senator.
Thank you.
Thank-
Senator Parker, you're recognized.
Thank you, Mr. Chairman. Thank you for your testimony and your service to Texas and Harris County, ma'am. The issue of this horrific delay that occurred in Jocelyn's case with regard to the laboratory issues, what could be addressed? What would you think, are there issues out there that you think need to be addressed specifically to stop that from occurring, if you will, justice from occurring because you're delayed by the laboratory report? Can you just give your thoughts on that after all the years you served in that role there in Harris County?
I'd say because it's dependent in many instances on municipal or county funding, unlike the DPS labs that are funded by the state, you're probably going to need to look at some mandatory testing deadlines, which impose a great pressure on state prosecutors dependent on municipal funding of their labs. In Harris County, they serve about 85%. The city of Houston files about 85% of the cases. The other 85 law enforcement agencies total about 15%. So the DPS lab is effective. The county lab is effective, but the city lab has all sorts of problems with staffing and training and money, et cetera. And it delays, it's the single greatest threat right now to our public safety because it delays the trials. And this is not a judicial issue. This is a funding issue by local government.
Thank you very much for the insight. Thank you very much.
Huffman?
Yeah, just briefly to address Senator Hinojos' point about the magistrate setting bonds and not being responsible. So SB 9, Senator Hinojosa, does require in certain cases that the presiding judge rather than a magistrate set the bond. So those are going to be people on parole or charged with 2 or more felonies previously and charged with the most, violent offenses. So that will help control that they have to be sent to the presiding judge, the elected judge, to make those decisions.
Yeah, and I read that, Senator,
Senator Hinojosa, you're
Senator Huffman, and quite frankly, SGR 9 really when we pass major legislation in this body, usually we have to come back another session to sort of make sure we fill in the gaps
Of
or
course.
things that may have gone wrong in the process itself. So that Senate SJR 9 really tightens that process and sets perimeters for the judges and a framework, so they cannot say they didn't know what, how they sent a bond for someone that shouldn't be here.
Yes, thank you. Thank you,
Senator
Mr.
Hagenbuch, you're
Chairman.
recognized.
Thank you. You mentioned the magistrates will give lenient bond on high-profile cases with no transparency, no explanation to the law enforcement or victims what the reason was, the rationale was. And I appreciate that you mentioned that at least the high-profile ones be handled by a judge. But do you think that even magistrates should have to give some kind of transparency or explanation for their determination on bail?
Yes, sir, we're the government, and people need to trust us. The only way they can trust us is to know what we're doing, and we have to be accountable for our records. So magistrates appointed by judges should not face less scrutiny than the judges themselves. Having them print their names legibly would be an excellent way to start.
Thank you.
Thank you. Thank you, Ms. Ogg. Appreciate it.
Yes, sir.
Mr. Ogg, your name and for the record?
My name is Brett Ligon, and I'm the elected district attorney of Montgomery County. We're the county immediately north of Harris County, Houston. Thank you, Senator Huffman. Thank you, Lieutenant Governor, for proposing SB 9. It's a really clever piece of legislation. Number one, Montgomery County has been referred to as Fortress Montgomery County for years. We've also been known as the Alamo. Long before Donald Trump started talking about border control, Montgomery County referred to border control as the border between Montgomery County and Harris County. And so we would have hard limits within Montgomery County. Senator Parker, to address one of your concerns about lab testing, DPS does lab testing, City of Houston does lab testing, but here's the difference between Montgomery County and Harris County. In those types of cases, we would submit those labs, before I would wait on a capital murder charge, we'd submit those labs to a private lab. So we have the ability. Now, as Kim's former DA Ogg, I've known her for years as well, as she referred to it, it's a funding issue, right? Montgomery County, 2 years ago, we filed 6 murder cases. Last year, we filed 12. They have so many murders, I think 1,200 pending murder cases in Harris County, that means somebody's been killed, an investigation, an indictment, and it's set for trial. They have reached the tipping point. I mean, now that's a whole nother issue. They can't dispose of as many cases as they get in every year. Montgomery County has made a commitment towards or against violent criminals for at least the last 17 years, and I think that's one of the reasons why they call us Fortress Montgomery County. Part of it's the policies. 4212, the Code of Criminal Procedure, Senator Huffman, as you know, says that's the procedure dealing with probation. It says you shall not violate the laws of this state, any other state, or the United States. So I took the position 17 years ago that if you're an illegal alien in Montgomery County, you're not allowed for probation. Number one, some people refer to it as a status crime. My feeling was it's conduct crime. You came here illegally, so you didn't get probation, number one. Number two, we had an ardent focus on violent criminals and habituals, and it's paid off. It's clearly paid off. But what I'd like to address specifically is the other 251 counties that are in Texas. So it's Harris, Dallas, Bexar, and Travis. And my wagon is hitched to some horses that are going in a direction that I don't like. I don't like it at all. The bad decisions that they make in Harris County become my bad defendants in Montgomery County. Now, a few of you represent the rest of the state of Texas. I should not be subject to bad decisions made by magistrates in Harris County. So let me talk, we're the 10th largest DA's office in the state of Texas, right? So we're either the smallest of the big boys, or I'm the largest of the urban and rural DA's offices. So we're right there on the edge. Our total capacity is 1,253 in our jail, 1,253. 10% are misdemeanors. That's what you want. 90% are felons. Currently, right now, we're 60 over our limits. So the Jail Standards Commission has already said, hey, we're in violation. 60 of those are illegal aliens, number one. Number two, 273 of them are Harris County residents. They're not Montgomery County people. I'll take responsibility for my Montgomery County people in a heartbeat. I don't know that if it goes far enough, Senator Huffman, I'm not allowed to sue Harris County for the $20,000 it's costing Montgomery County a day to house Harris County and Houston residents in a Montgomery County jail. But I am forced to deal with Harris County's mess. I love the legislation, but here's the clever part. It also puts an elected district attorney on the precipice of judgment. The way it's written right now, it says, hey, a DA can appeal. Great, I like it if it's an insufficient bail. It's about time for DAs for their report card to be checked as well. Now, I am confident that Sean Tier is going to come in and he's going to do what he can to turn things around in Harris County and to attack the murders and the violent crimes. But Sean Tier and Brett Ligon and Jennifer Tharp and all my friends, we should have a report card too. Hey, I'm responsible if I don't appeal an insufficient bail. Well, I think that's a reflection. I don't know if that was intended, but if it wasn't, it's an unintended positive benefit to make everybody accountable, not just judges, but elected DAs as well. So we're in favor for it. Look, these criminals don't stay in one place. I can tell you over and over, 5 bounds in Harris County, guy picks up an evading in Montgomery County, wrecks out a cop. 3 bonds in Harris County, picks up an evading and assault in Montgomery County. Capital murder out on pretrial detention in Harris County, picks up a murder in Montgomery County. 3 bonds in Harris County for PCS and the theft and picked up. They got another one, 7 bonds out of Harris County. It would at least allow Sean the opportunity to appeal those bonds so that those people stay. So if you don't have compassion for Harris, Dallas, and Bexar and Travis because they brought it on themselves for who they elected into office, then please have compassion on the other 251 counties that don't want part of this mess. And our rural wagon is hooked to an urban set of horses that are going in a direction that's leading them off the precipice. So I'm here in support, Senator Huffman, Lieutenant Patrick. Man, thank y'all so much. Great piece of legislation. Let's get it done.
Members, any questions? Thank you.
Thank you. Thank you, Brett.
We'll move on.
Thank you. Good morning. My name is Jennifer Tharp. I'm the Criminal District Attorney for Comal County, and I'm very pleased to be here today to testify in support of all of the legislation that's been laid out. But I'd like to focus predominantly on SJR 1. 10:30 p.m., August 24th, 2020, Sacramento De Jesus Martinez began his night of devastation and violence that encompassed 3 cities, left multiple people injured, 2 innocent people dead, and 3 children effectively orphaned by early morning. Fueled with jealousy, rage, cocaine, and alcohol, Martinez was losing control over his estranged wife, Marisol, age 33. Because she attempted to end the relationship, and she did so by virtue of getting a protective order, her own apartment for herself and her 3 children. She got that protective order because Martinez had strangled her, raped her, assaulted her, threatened to shoot her with a taser while raping her. And the violence ended that night only because she was able to run away from him and call for help. He was arrested. He was not here legally. He was an illegal alien that was given a bond. She got a protective order. She tried to do everything right. She got her own place. However, on this night, Martinez went to the apartment Marisol shared with her children, armed with a .38 revolver and a bag of bullets. Their daughter, teenage daughter, testified in our jury trial, and she talked about that night having dinner with her mom and her siblings in the apartment. She talked about her father calling her mom's cell phone time and time and time again. Her mom answered it. There was an argument. She hung up the phone call, and he kept calling. She talked about later on that night, before she went to bed, walking by her mom's bedroom door and seeing that it was locked and thinking that was unusual. But she went to bed. She testified hearing a noise in the middle of the night, thinking it was probably someone from the neighbor, and shook it off. But then something didn't feel right, so she got up and went in and checked in on her mom to find her mom's bedroom door open, unlocked, and her mom nowhere to be found. That teenage girl spent the next several hours calling and calling her mom's phone and her dad's cell phone. Her dad finally answered the call, would not let her talk to her mom to make sure her mom was okay. And the last memory she has of her mom was hearing her mom crying in the background when she talked to her dad. She then called his sister multiple times. The sister called him, tried to also talk to Marisol to make sure she was okay. He wouldn't let her talk to her and said, "No one is going to make me look like a fool any longer."
They called the police. The police started hunting, trying to find Marisol that night. He left that apartment with Marisol, drove around Austin, arguing about how she could not leave him, and he wouldn't let her leave him, shot her in the face, and left her in the front seat of that car while still driving around Austin. He then drove to a McDonald's where he met up with his dealer to buy some cocaine, convinced the dealer sold him bad cocaine, shot that dealer in the face. He lived, then goes to another intersection in Austin, approaches a group to try to buy even more cocaine, convinced they also sold him bad cocaine, shot at the group, injuring an innocent bystander. That person lived. Then convinced these individuals are chasing him, gets in his vehicle and heads south towards San Antonio to where his sister lived. Marisol is deceased in the front seat of the vehicle. While driving from Austin to San Antonio, he drives to New Braunfels. Convinced someone is following him through New Braunfels in the middle of the night, he exits the highway, loops around, and starts to head back north towards Austin. His car breaks down. He ditches the vehicle on the side of the highway in New Braunfels and sees a TA truck stop nearby. Goes towards the TA truck stop, which happened to be next to a DPS station, so we had all kinds of surveillance video showing this. Comes up through the TA to the TA truck station, coincidentally right around the same time that Daniel Seeger, age 45 from Mission, Texas, had just backed up his 18-wheeler for the night to rest. Walks straight up to the cab of that vehicle and kills Daniel Seeger, shoots 4 times within a rapid succession in seconds, shoves him out of the driver's seat, then takes his 18-wheeler on a high-speed chase from New Braunfels to San Antonio. Multiple callers witnessed the erratic driving. Vehicles were struck. Incredibly dangerous, so much to the extent the way he was operating, he ultimately rolled the 18-wheeler in San Antonio. Ditched that vehicle, came upon another group requiring them to give him a ride ultimately to his sister's house. Thankfully, because of that little girl's phone call and the aunt's phone call to law enforcement was quickly able to apprehend Martinez at his sister's front yard, still with the gun. He had killed Daniel Seeger and Marisol that night. He was out on bond. He was not here legally. That night was Daniel Seeger's first job. First night on the job. He was so excited because he wanted to see the United States, wanted to see every national park, and that was his way to see the country. Marisol was a good mom. She tried to do everything right to get herself out of a dangerous situation and keep her children safe. Those children, I say, are effectively orphaned because their only surviving parent is a murderer and a monster. If this situation and every heartbreaking thing you've heard this morning does not justify SJR1, I don't know what is. How many more people have to die? And when you look at the purpose of bail and when the definition of bail was adopted by this body in 1965, it's a means to secure someone's appearance in court. If they're not here legally, and they've been arrested for committing a felony, I don't know how else to argue or articulate flight risk than that. In Texas, we brag about being the best state in the nation, and in a lot of ways we are, but when it comes to this, we're not, and we've got to fix it. We got to do the right thing. It is not partisan. It's about just doing what is right. Thank you for everything.
Remember any questions? I just have one question. So his arrest and bond, was that in a jurisdiction that is a sanctuary city who doesn't qualify?
Yes, it was. Travis County. Yes, it was.
So that was a consequence of adopting a sanctuary city
We are
policy and
we are not a
cooperating
sanctuary
with
city.
ICE. And
Similar.
So this man went out and killed his wife and killed a citizen because of that policy. Well, that policy was a great part of that. Would you agree with that statement?
100%. What Brett talked about in terms of being pulled by larger jurisdictions, I have San Antonio to my south, and I have Austin to my north.
Whichever.
Senator Hinojosa, you're recognized.
Just Point of clarification. So where did this person, how did he get into the United States?
He illegally crossed. I can't tell you which port of entry, how he came. I know that when he was arrested in Travis County, he was flagged as an illegal citizen, or excuse me, illegal alien. And there was ICE was not notified. There was not any detainer that was put in place. He was given a $15,000 bond for strangulation, sexual assault, and terroristic threat.
And a while ago, I was making the point that about the number of immigrants come across asking for asylum, which are families are less than 50%. When they pull the Border Patrol to assist them in the asylum process, they leave these huge gaps along the border. And we have evidence that shows 25, 30, 40 males, grown males coming across. We don't know who they are. And that is part of the challenge in trying to deal with this issue to make sure that our public is safe. Thank you.
Thank you for that comment. I will tell you one of the struggles with a capital murder case that I talked about, we tried him for capital murder, is when you're reviewing and considering whether to seek the death penalty or not, you have to know their history. And there's a huge gap in that. And we used every local, state, federal, and international contact we could get through any agency to try to find his history to make that determination. And there's a huge gap on information. So understand, too, that when we do have these horrible cases, a lot of times we're flying blind because we don't know what all that history is. As you explained earlier, and Chair Flores, you said that, too. We don't know all of their history, what they did in Mexico before coming across illegally.
Well, it'll be very difficult to obtain a criminal history on that person for a simple reason. Some of these countries where they come from don't have a system set up to be able to track that type of information.
That's exactly right.
Thank you. Members, any other questions? Thank you very much for your testimony and your service to Texas.
Thank you, Judge.
Good morning, Chairman Flores, Senator Huffman, and Senators. My name is Megan Lavoie. I'm the Administrative Director for the Office of Court Administration, testifying here as a resource on SB 9 specifically. As you know, OCA was instructed to implement SB 6 in the Public Safety Report System that went live in April of 2022. The Public Safety Report System does two things. First, it provides information about the defendant to the judge, including their criminal history and whether they're eligible for a personal bond. And second, it provides a mechanism to report bond decisions at the state level through a bail form. As of yesterday, just a couple of statistics, over 7,000 users are active in the system. So that means judges, coordinators, jailers who are using the Public Safety Report System for this information. Over 1.5 million bond forms have been completed since inception of the system. That averages out to about 500,000 bail forms every single year. About 45,000 bail forms every single month are reported in the system, and all of them are required to be published on our website, and they do include the name of the magistrate that made the bond decision on the bail form. Class A misdemeanors continue to be the most reported offense type, with possession of a controlled substance less than a gram, assault causing bodily injury to a family member, and DWI are the top offenses overall in the system for the past 2 years, making up 17% of the offenses in the Public Safety Report System. For the most part, 84% of the bonds being set are cash or surety bonds, 12% are personal bonds, and 4% are a denial of bail. And who is setting these bonds? 31% are magistrates, 18% are justices of the peace across the state, 15% are municipal judges, 15% are county judges, and about 8% are district judges. I look forward to working with you, Senator Huffman, and your office and the other public safety agencies and stakeholders in making improvements to the Public Safety Report System and giving judges the tools and information to make these very critical decisions. Happy to answer any questions.
Members, any questions?
I just have
Senator
one.
Hinojosa.
I know y'all have done a great job in implementing the legislation trying to reform the bail system. But are those cases where there is a PR bond set? Do we know what type of charges were filed against the person who got a PR bond?
Yes, all of that information is in the public safety report system, and we also have dashboards with all of this data, and you can filter it by county, by offense type, and by personal bond.
Are those most misdemeanors or felonies, a combination thereof?
I believe most of them are misdemeanors because there's several restrictions on who can be released on a personal bond for felonies, but I'm happy to filter that information, provide that to the committee and to your office.
Thank you.
Thank you. Any more questions? Thank you all very much for your testimony.
Thank you so much, all of you.
Chair, now call Shannon Edmonds, Andy Cahan, and Luz Dove.
How are you?
Good morning.
Good morning.
It's still morning, yes. We'll start with you, Ms. Dove.
So my name is Luz Dove. I'm one of the senior directors with the Crime Records Division of the Texas Department of Public Safety. I'm here to testify on SB 1047. To let you let you know, the department currently provides TCIC data to the PSRS through our current resources and our current interface with the PSRS. We provide Texas and national criminal history, conditions of bond, and also reported failure to appears that are contained within the criminal history. We have, based upon the bill, we have and can provide active current warrants to the PSR. We don't currently provide that, but we can, as well as current and active protective orders. We don't house any archive data on the protective orders, so we would only have the active. Information that we don't have available currently today, I'm sorry, can everybody hear me okay? Information we currently don't have available is the supervision data that's currently held by TDCJ or TJJD or any of the local probation offices, parole and custody entities. We are happy to develop those interfaces. We would need to understand how we would do that since we aren't the holders, and we are currently in a modernization of our systems. So we would want to look at the requirements, see how they impact our contract, and then move forward. We'd love to work with your office and OCA to understand how to make this work for Texas.
Senator Huffman?
We'll make sure you understand.
Thank you.
We'll work with you and make
Yes.
sure that we get the funding and the technology needed. Yeah, all the systems need to be able to talk to each other, as they say. Yeah, and that's something that's probably needed to have happened a long time ago, actually. I was sort of surprised of kind of how antiquated it all is, so. Anyway, we'll work on it, but it's an important part so that the judges can have the information, but we'll get there.
And that concludes my testimony. If anybody has any questions, I'm happy to answer on behalf of DPS.
Thank you. Any questions, members? Thank you. Mr. Edmonds?
Thank you, Mr. Chair and members. My name is Shannon Edmonds. I'm the Executive Director of the Texas District and County Attorneys Association. I appreciate the opportunity to be here as a resource for the committee to answer any questions they may have. The only prepared remark I wanted to make concerns SJR 1 and SJR 5. Y'all pass those things and they go to the ballot, and people don't normally remember what the votes are when those measures get on the ballot. But in regards to amending the Constitution to allow judges the discretion to deny bail, it's been almost 20 years since you passed legislation like that in 2005 and again in 2007 in bills brought by prosecutors who wanted to give judges that discretion in cases involving family violence, repeat offenders, and violations of protective orders. Those measures passed by 84 and 85% of the vote. And prior to that, the last time the people of Texas were given an opportunity to give judges the discretion to deny bail for offenders who committed certain serious felonies, violent crimes, and sex crimes while they were out on parole, that measure passed by 84% of the vote. So that may give you a little, I know as Senator King said, things have changed in 20 years, but I don't know that that has changed. When people are given these opportunities, they tend to like it. And I'm happy to answer any other questions on this legislation.
Members, any questions? Mr. Cable?
Good morning. My name's Andy Kahn, Director of Victim Services for Crime Stoppers of Houston. Unfortunately, I'm not going to be as quick as both of you. So bear with me on this. Thank you again for Senator Huffman for once again spearheading. And I'm actually going to, when I get moving on, you'll hear some of your quotes in 2021. And we're still here talking about the same mission. I'd like to thank the Senate, too. I mean, you guys have really picked up the ball. And like Senator Huffman says, the third time has to be the charm, or the fourth time. I don't even know where we are right now. So I'm going to start off talking about SJR 5 and the constitutional amendment. I'm going to read to you notes, comments that were made. I'm not going to mention the Harris County District Judge that made the comments, because you rarely have a judge that actually submits written remarks, but he did, and he's a Democrat judge in Harris County. And I'm just paraphrased right here. He's talking about, at that time, SJR 44, which is now SJR 5. And he says, public safety is a factor that's always taken into account when setting the amount of bail and the appropriate bond conditions for a case. However, in the event a judge finds that there's no bond conditions sufficient for the protection of alleged victims in the community as a whole, there's no mechanism in our law to deny bail. Furthermore, case law has prohibited judges from setting bail in an amount specifically to keep a defendant in custody. That's why you don't normally see 5 million, 10 million, things of that nature, because judges cannot set exorbitant amount of high bonds. It is against the law to do that. Therefore, even if a judge believes beyond all doubt that a defendant is a danger to the public and victims, the judge must set a bail that does not violate the defendant's right to liberty. By allowing judges the ability to hold a defendant without bail after a hearing based upon specific findings, judges would now have a tool to address that shortcoming in the law. While I, like many Texans, I'm always skeptical of increasing governmental powers, I do believe that this resolution will have a positive impact on public safety and will advance our criminal law towards a fairer system of pretrial detention. This judge has been elected twice in Harris County. He's a Democrat judge. This is on the record. I would urge everybody to take his comments into consideration right here. My perspective is I don't see any downside in allowing discretion. It's simply discretion. It's not a mandate. It's not going to be a panacea like some might want to say, where people are, the jails are going to be filled with people. It's for those that truly represent a danger and a threat to the community right there. I'm going to go over some case examples, real life examples. And we've been doing a series in Houston, Harris County, for over 4 years. It's on local Fox News. It's called Breaking Bond. For a news station to be focusing in on a single topic, now going on 5 years, every single week, is unheard of. This has never happened before, and we never run out of material to present. Every week it's a different case showing some of the failures of the repetitive bond system and people that end up paying their price, usually by losing their life. So one individual here, Travian Tatum, he was on bond, $50,000 bond for 2019 murder. He was charged with aggravated assault while on bond for the murder. Then he was given another bond for the aggravated assault. He violated his bond conditions numerous times. Nothing happened to him. Then in 2022, he was charged with another murder and aggravated assault and wounded 2 others. So keep in mind, he's already out on bond. He gets charged with another violent offense, aggravated assault. He's given another bond. Nothing happened, and now he's charged again with another murder. He recently pled guilty, was sentenced to 99 years in prison. That person should have been alive. There's no ifs, ands, or buts. 2 of the cases that Governor Abbott highlighted in his State of the State address had to do with the murder of off-duty Deputy Harris County Precinct Omar Ursan. Both of these defendants were on bond for murder at the time. One of them was on bond for capital murder. He was actually charged with capital murder. The bond was originally set at $200,000. For whatever reason, this particular district court judge decided $200,000 was too high for capital murder, reduced it to $75,000. He posts bond. Now he's charged with the murder. This one right here, I really, you see the hair on my head? I know Senator Hinojosa, you can relate, right? Yes, we can. This is gone. So this one guy, Frank Niorje, he's on probation for assault with intent to impede breathing. He's then charged with assault violating protective orders. He posts a cash bond, $27,000. Then he's charged with assault of another family member and another assault with intent to breathing. He's actually given $100 bonds for those. Days later, he's charged with another family assault, another bond set. Then he's charged with another family assault, sexual assault, kidnapping, $100 bonds for sexual assault, kidnapping, family assault, and tampering with a witness. $100. There was 4 motion to revoke probations filed. Nothing resulted in revocation. There was a total of 7 $100 bonds that were given to this defendant. You can't imagine the horror of this victim. I spoke with the victim's family. We had to shield them from going public because this person kept getting out, and the bonds kept getting lower, and lower. I mean, I don't know how you justify this. It simply defies logic. Jeremiah Jones, multiple felony convictions. He was out on 7 total bonds. He was out on bond in June of 22 for felon in possession of a weapon, felony evading arrest. Keep in mind, he was already out on bond for burglary, another felon in possession of a weapon, and yet another burglary. 12 days after he's out on 7 felony bonds, a 9-year-old girl was killed. He's charged with capital murder. I could go on and on. This one, Senator Huffman, is probably near and dear to your heart because we have Omarion Bailey, who's charged with murder by fentanyl. One of those first cases that we got there. Before he got charged with murder, he had multiple felony convictions. He was on bond for stalking, misdemeanor assault, retaliation, and criminal mischief. The murder occurred in September of 23. He gets a bond for the murder. The original bond was $250,000. It was reduced to $150,000. Then it was reduced again to $100,000. He does manage to post the bond for the $100,000. Then he's charged with stalking and retaliation. Keep in mind, he's already on bond for murder. He's given more bonds for stalking and retaliation. He's back out on bond. He's on bond as we speak right now. There have been multiple bond revocations filed. There's a total of $215,000 for 3 felony bonds, including murder. Those are just some of the examples that we've managed to cull regarding this. I would urge this committee to get this out. I know it's going to come out, but I urge the House, let Texas voters decide. They should decide whether this is a good bill or a bad bill. But I implore the House not to basically stymie the Texas voters for having the opportunity to weigh in. Judges will use ample discretion. People aren't going to be all of a sudden, no bond, no bond, no bond. It will be used very judiciously. But they have to have that tool to do that. We have to give them to that. Right now, all we hear is, well, hey, like in the Nungary case, we have to give a bond. You're correct. And we have to give them discretion. That's our job over here as well.
Thank you, Chairman. I guess two points. One, the SJR 5 provides the prosecution the opportunity to appeal a bond that's too low. But this is not just a problem in Harris County. Down in South Texas, in Jim Wells County, we had a person who killed his mother. He admitted killing his mother. He was out on bond. And out on bond, he went and killed his wife. So it is a serious issue that we have, not only in Harris County, but throughout the state of Texas. people that are on bond that should never be on bond, and really places the public in danger.
You know, I'll give Crime Stoppers a pat on the back, obviously, because I work for them, and I'm contractually obligated to do that right now. But we are the only entity in this state that is documenting anything out there. And like Senator Huffman said, and we prepared a 5-page report that I'll be happy to share with everyone else as well, where we identified over 150 defendants who were out on bond at the time when they were charged for murder. We're also going to be working on defendants who are currently out on bond and see how many of those have now been charged with additional crimes. I get asked all the time, well, what's happening in Dallas, San Antonio, Fort Worth? I don't know, because no one else is doing this. I would think that as a committee and as a state, this would be something that we would want to do statewide and know. I know what's going on in Harris County because we've been given the task of doing that. And so again, this is what I know just from Harris County. It's what scares me is what I don't know. And that's something that needs to be discussed.
And it's important that we shine a light on those type of issues that exist throughout our criminal justice system throughout the state. Thank you for working.
Yeah.
Senator Huffman.
Just a couple of questions. One, to your point, Andy, about us not having the data. My staff and I are working on legislation to get filed here soon, as soon as we get it written and drafted, to do just that and require, and probably it'll be the large urban centers, to keep track of this information.
Good, because I'm getting tired of doing this.
Make that happen. So when we come back in 2 years, those of you from Dallas and other areas will have good information as well. And I also want to reiterate that piece of data just to make it very clear. So would you keep track of the murders? But since January of 21, there's been at least 162 homicide cases filed in Harris County for defendants released on one or more bonds at the time of the commission of the offense.
Correct.
All right.
Yes.
Let that sink in. And that's since we first passed this legislation. And that's what we want the House members to listen to. There's 100, and we can give you the names of the people. Just heartbreaking. Every last one of them. So you could, we can sit here and talk about data and bills and, common sense, but it's just, you could write a novel about every one of these stories. They're just, it's just wrong.
No, in 2021, Senator, you might remember Teresa Seck that came up and testified after her brother was murdered because the defendant was out on 7 felony bonds in 2 different counties and actually had 2 ankle monitors on him from 2 different counties. That, you can't top that one.
Hard to top that one.
When both counties decided, why do we have 2 ankle monitors, they decided that we'll just eliminate one of them. Okay, so I remember getting a call from Teresa. She said, I've seen you on the news all these years, my family. She goes, never in my wildest dreams did I ever think I'd be reaching out to you. And here we are. And I'm so, your brother's loss was such a tragedy, but it was so utterly preventable. We had an off-duty New Orleans police sergeant and his colleague. They were at the Grotto, a very upper-scale place in the Galleria area.
Right in the middle of my district.
This was a Saturday at 5 p.m. They were sitting outside having drinks, and they were jacked up by at least 4 individuals for their jewelry. They decided that they didn't like what they were getting, and they shot and killed the off-duty New Orleans police officer. One of those defendants, it was 19 years old, Frederick Jackson, extensive juvenile criminal history. He was out on 5 felony bonds in 2021. One non-sequential, one after the other. So I take the other spin on this. Do you think the courts did him any favors by releasing him time after time? It was fairly obvious. I would think after maybe the 4th one, you would kind of think there's a pattern here. You didn't do the 19-year-old any favor. He's now doing life without parole. So I take other spin. When you continue to punt people who it's fairly obvious, and we're focusing on repetitive bonds, it's fairly obvious on that. You're not doing defendants any favor because a lot of times you're just escalating the likelihood of getting more and more criminal activity and more time in a prison there as well. Very quickly on Senate Bill 1047, we've heard a lot of talk about magistrates and PR bonds. The magistrates are the gatekeeper. Crime Stoppers actually has data. And we have 28,000 defendants in Harris County that were given PR, personal recognizance, get out of jail free cards by magistrates over the last few years. One magistrate gave six defendants 6 PR bonds. 19 were given 5 PR bonds. 68 were given 4. 359, 3, 2,521, 2, and the rest were given a single bond. I have all this by the magistrates. Again, that's something I hope that the bill that you have would incorporate this, because it's important to know. And I see it all the time in Harris County. I see a PR bond given to a defendant, and then I actually see the elected district judge a few days later revoke that PR bond, take it away. So there's got to be some give and take with that particular issue on that as well. One of the things that we talk about right here is the PR bonds that are being given. I'll give you another case example, and these are real life examples, real life people that are affected. Dominique Menifee was on parole for aggravated robbery with a deadly weapon. While on parole, he was charged with a felony. A magistrate gave him a PR bond. He walks out. 5 days later, the parole division issued a warrant for violation of parole for being charged with a felony. On the 6th day, he's charged with killing the mother of 3, 34-year-old mother of 3. People on parole, especially if you're on parole for a violent offense, should not be granted a PR bond. That decision cost Shanika Banks her life. Jesse Ortiz was on parole for a violent offense. He's charged with felon in possession of a weapon. He was given a cash bond. 4 hours after he was given a bond, the parole division issued their warrant. That was 4 hours too late. 2 months later, he's charged with capital murder. I could go, again, on and on and on about these. One of the categories that we focus on at Crime Stoppers is the issue of felon in possession of a weapon as well. And I'm talking another category as well, possession of prohibited weapons, which involves machine guns. We have hundreds and hundreds of defendants. Keep in mind, gun violence is everyone's talking about gun violence, gun violence, gun violence, right? What can we do? When you have someone booked in for felon in possession of a weapon, that's a felon in possession of a weapon. How do you justify giving that person a PR bond? But it happens routinely, over and over again. How do you justify someone who's charged with possession of a prohibited weapon, a machine gun, getting a PR bond? But it happens. So we want to talk tough on gun violence, yet we have defendants routinely being released back to the community on personal recognizance bonds. This has got to end if you're going to take serious calls on that. So I'm pretty much talked out. But if you have any questions or anything you want, Crime Stoppers is the entity that's taking care, that's taking a deep dive into this. I'm very proud of our organization for doing something that no one else is doing and for recognizing it's a problem. Crime victims are the only unwilling participants in the criminal justice. Everyone else chose their role. Prosecutors, defense attorneys, law enforcement, victim advocates, but no one ever said, pick me, pick me. I want to be a victim of a crime. When you look back here, that's the least we can do, is to look out for their rights, their due process, and their well-being. We want equal treatment. As sad as it says, I'm not saying that defendants shouldn't have it, but in a sad reality, it's time to put victims' rights back where it belongs. And I appreciate you guys giving me the time.
Thank you. Thank you for any questions, members. Thank you all very much for coming and sharing your experience and knowledge. We appreciate it. Is there any additional invited testimony on these bills and committee substitute? Hearing none, we will proceed to public testimony. Chair now opens public testimony on committee substitute for Senate Bill 9. The chair calls the following witnesses: John Wilkerson, Jennifer Szymanski, Aaron Johnson, Alina Bangs. And when you come forward, you please identify for the record, speak into the microphone, Public testimony will be limited to 2 minutes on each bill, subject to the discretion of the chair. If you have written testimony, please submit the copies to our committee staff to the desk to the right. Do we have everyone that we called? We'll begin on my right, and you have 2 minutes. Please state your name.
Good morning, Chairman and members of the committee. I'm Jennifer Samansky, the Deputy Executive Director for the Combined Law Enforcement Associations of Texas, or CLEAT, testifying in support of Senate Bill 9. Our organization represents over 28,000 law enforcement officers across the state, to include the San Antonio POA, Fort Worth POA, El Paso POA, Corpus Christi POA, and over 2,400 officers between the Dallas and Austin police departments. We also represent the deputies associations in our large urban counties, and while we have members across the entire state, I'm highlighting these areas as House Bill 9 seeks to right the wrongs of the actions taken by judges across heavily populated regions. While magistrates, judges are not the only offenders of letting criminals off easy, this legislation is a massive step in the right direction. While there is a surplus, obviously, of these horrific stories, victims, and tragedies that precede this legislation, I will focus on the most recent occurrences, like the 7 San Antonio police officers shot in the line of duty last month by a violent offender who was out on a very low bond, or the 5 suspects arrested here in Austin, Travis County last month on capital murder charges, all out on bond. I'd also like to address another portion of the bill. After being bailed out of the Bexar County Jail by the Texas Organizing Project, a violent and mentally ill individual, Shane James, promptly cut off his ankle monitor, which at the time was not a criminal offense. Now it is. James had access to firearms and was a clear and present danger to the public. Critical information pertaining to a suspect's mental health, access to firearms, and details regarding their past criminal episodes are not available to the public. Therefore, advocacy groups with no access to the relevant facts should be arbitrarily bailing out criminals, especially on the taxpayer's dime, which I didn't learn until today. That's incredible. Thank you.
Testimony.
Good morning. My name is Elena Bangs, and I've been a prosecutor in Tarrant County for 18 years. I have served in both the gang unit and the intimate partner violence or domestic violence unit over those years. And as you might imagine, what I can tell you from my time in both of those units is that recidivism and violence are to be expected. And without appropriate bonds and stringent bond conditions, we can always expect more offenses to occur. The courts have a duty to keep the victims of those offenses and other members of our community safe while the wheels of justice turn, even when they turn slowly. And community members vote for and elect judges to take that responsibility seriously. On January 9th of 2022, Valerian Osteen was arrested for aggravated assault and unlawful restraint of his girlfriend, Marissa Grimes, in Fort Worth. At the time that his bond was set at $10,000, he had already been convicted of 5 previous felonies and had numerous violations in our local history of noncompliance with courts. He was bonded out, and he was out 3 days later. By February 16th, a month later, Marissa Grimes' parents were calling a missing persons report in, and obviously what police later learned via a search warrant is the worst possible scenario. She had been bludgeoned to death by Mr. Osteen and buried under the crawl space of his home. All while on a leg monitor and on a $10,000 bond. His leg monitor was removed when he was booked back into the Tarrant County Jail, and he will be tried for capital murder this spring. That bond was set by a magistrate. In my county, we have 11 district court judges and we have 16 magistrates. They set the bonds in those cases, and those bonds do not appear on elected officials' desks. I urge you to take a strong look at Senate Bill 9 because it is a reversal that we need in bail reform.
Thank you.
My name is Aaron Johnson. I'm the president of the Texas Association of Pretrial Services. The goal of our agency is to support and advocate for the appropriate pretrial release and diversion of eligible defendants in the state of Texas, consistent with the Constitution of the United States and Texas. In regards to the priorities which I have submitted, We created an advisory committee this year after I came and testified back in June in regards to some of the bills that we're talking about today, which was made up of the judiciary, district attorneys, public defenders, probation, community resource, and pretrial practitioners across the state. And what follows and was submitted is the work of the TAPS board and the advisory committee in regards to legislative priorities, how we feel they will move the needs of the association, the state, and defendants to work better with safer outcomes for the victims of crime as well as the local populations. In regards to Senate Bill 9, I think there is a lot of effort being put forth to make some changes to and updates to Senate Bill 6. But I would challenge this committee actually to look at the state of Illinois, because a lot of the discussion that we talk about in this conversation, and now for my own part for the last 5 years in the state of Texas, is regarding money. And as long as money is a stakeholder in this conversation, we are going to continue to come back and talk about, well, how much money? Well, why did these people get to get out? Why did they not get to get out? When we talk about a system where it is actually based upon an in or an out system, then I think we're going to really start taking things seriously. Until then, we're just going to keep talking about how much money is going to put in here, what magistrate did this, what district court did this, how much money, and then you're going to come back to them and say, well, how much is enough? When are we going to have a serious discussion about actually identifying people who are safety risks to the community versus people who we just don't know what else to do with? And so jail becomes that holding place for these individuals.
Thank you. Thank you for your testimony.
Chairman and committee members, thank you very much for hearing this very important legislation. I'm not going to repeat a lot of what you've heard here this morning. My message is very simple to you. Law enforcement as a whole is very much in support of all of Madam Chair's legislation. Every Monday morning, TMPA, which is who I represent, we co-chair with the Dallas Police Association, Harris County Deputies Organization, and the Houston Police Officers Union. And we facilitate a meeting of all law enforcement down here at the Capitol. And the other chairman wanted me to echo the sentiments that all the law enforcement that works down here, we are in full support of this legislation. In fact, we want to say that there's been a dark cloud over law enforcement for several years now because of this, because of the broken bell system that we have. And the chairwoman's legislation is shown to be light at the end of that very dark tunnel. So we want to say thank you for your work on this matter.
Thank you, members. Senator Hagenbooth, you have a question?
Yeah, just appreciate all of your testimony. We've heard the terrible things about victims, and that enough is enough to motivate her, I would hope, to pass this law. But in terms of law enforcement, you're speaking about law enforcement, you hope that you represent them. About the morale of law enforcement, we've seen what's happened in this country with defunding police. I have to imagine, I have law enforcement in my family that has to hurt their morale. But when you do all the work and effort to, do your job well in the field, bring a violent criminal or violent defendant to a judge or magistrate, and they're just released on bail, how does that motivate you the next day when you go to work? How do you go back to work and actually, have the motivation to really do your job?
Yeah, Senator, during the interim, one of the hearings, that very issue was brought up. And that's one of the things that TMPA mentioned is sometimes it is hard. You go out there every day, you put the same people in jail, and before you can even get your report done or refuel your patrol vehicle, they're already passing you on the streets. But we stay committed. We're going to continue doing the job, and we're going to continue working with this legislature to pass meaningful legislation that helps keep Texans safe.
I would also like to say as well on that note, another piece of the bill that goes directly to what you're talking about is, yes, it's extremely difficult. Morale is very low and safety is a huge concern. This notion where the probable cause affidavits are being rejected, this is happening at an extremely high level in Travis County. I can tell you as an Austin police officer, I have had a very high number of PC affidavits come back with no probable cause or lack of sufficient probable cause written by the judge or magistrate on the PC affidavit with no explanation. So like was mentioned by District Attorney Ogg, how is the officer there's ample probable cause in the affidavits. How is the officer, supervisor, or chiefs supposed to take that back and make them better, as she mentioned? It makes no sense. There's plenty of probable cause, and they are being rejected at a very high level.
Well, just to follow up on that, I mean, her point is, even say you didn't do a good job, made a mistake, but if you have no feedback, how do you improve? It doesn't make sense.
Exactly.
That's a valid point, Senator. I'd like to add one thing to that. If you don't know, you can't grow, right? So getting that information is very important. But then another aspect to that is without that information, it erodes the trust between the law enforcement community and the citizenry that we protect, because their automatic input to that is to say, well, the police made a mistake. And fact of the matter is, we probably didn't, but how do we know? How do we prove that? How does the public see that? Thank you, sir.
Senator, may I add one point as well to that? As a prosecutor, something also that we see rather frequently when you're talking about morale and the safety of our officers is that when these individuals are let out on bond and then they commit a bond violation, we are calling these same officers and asking them, our SOs and our U.S. Marshal Task Force, to go pick these people back up. And you would imagine the morale hit of that, not to mention that is where, as prosecutors, we are filing assaults on public servants and homicides of our public servants, because arrest of domestic violence offenders is one of the most dangerous possible things for our public servants.
Yeah, you have to be putting the law enforcement in serious danger that way.
Senator, I'm right back there.
Thank you. Members, any more questions? Thank you very much for your testimony.
Thanks, sir.
Thank you all for being here.
Thank you.
So the chair calls Ken Good, Steve Huerta, Adam Haynes, and Charlie Malouf. I hope I pronounced that correctly. So we'll start on my right. And remember, you have 2 minutes. Please state your name and proceed.
Mr. Chairman, I hope I'm on your right. Adam Haynes with the Conference of Urban Counties, here to testify in support of Senate Bill 9. And you've heard a lot this morning. I'm not going to repeat anything you've heard, but CUC represents the 35 largest counties, but specifically for the purposes of this bill, we represent more than 85% of the cases going forward. And just remember that counties are the first door of justice for every case that represents a bond or represents an issue. And so all of the cases that you've heard about today, or any of the cases that deal with bonds, whether they're district court, justice court, county courts of law, they come through the counties. And so we are here to tell you that Senate Bill 9 is an improvement to what's already passed. It'll give judges a good guide and a set of guidelines so that we can make informed decisions and have more uniformity on decisions. And I'm also here to tell you that while we do think it will increase our jail pops at the county level, you're going to hear some, or you may have already heard some, or you've gotten letters in your office that's going to inundate. We don't think it's going to inundate our jails. We'll deal with it. We'll deal with prosecutors. We'll work with prosecutors. We'll work with our sheriffs to make sure that we stay in compliance with our jail pops, and we'll be able to implement this needed change. The one thing I will say is that and I've already talked to Senator Huffman or Senator Huffman's staff, is in the first section when you list there that you've got to do the report within 24 hours. We would suggest that you certainly in Denton County, Vice Chair Parker, and other counties, we've got 24/7 magistration where we'll handle them. But in smaller counties, you may want to extend that out to 48 hours or so. Thank you. I'm not going to answer any questions.
Hi, my name's Ken Good. I'm with the Professional Bondsmen of Texas. Thank you, Chairman, and the rest of the committee for hearing my testimony. The bail community is in full support of all the bills and the SJRs. I want to highlight two things on SB 9. I like specifically the part where the magistrates cannot grant bail for certain offenses. We've heard today about maybe politics as part of the problem. I want to identify one other issue that I think is part of the problem. In our JP school, in our magistrate classes that we're teaching to them, they're being taught that they cannot deny bail. There's a specific reason for that. There's 4 provisions in the Constitution where a judge can deny bail. One of them is for capital murder. There's not any judge mentioned on that. It just says you can deny bail for capital murder. The second is 3-time offender. It says only a district court judge can deny bail there. The second, the third, and the fourth are violation of conditions or violation of a court order dealing with some type of family violence. Those specifically mention magistrate. So, but the one that says district judge has a case interpreting it, saying it can only be a district judge. So as a result, our magistrates and our JP judges are being taught that they cannot deny bail. I think that's contrary to the law. When I speak to judges groups that are county judges and district court judges, they think I'm just lying about that's what they're being taught. I spoke to, I think, the head of the JP Association just this morning just to confirm that that's what they're being taught. He did confirm that. And on the issue of the SJR about not being eligible for bail if you're here illegally, we fully support that. That is an issue right now about what do we do in the bonding community if we post a bond, which helps the counties get somebody out of jail. We want them to appear for court, but then they've decided they don't want to prosecute. They want to get them out of the United States. If that happens, then there's a failure to appear, and the bondsman is responsible for that. But also, we don't have somebody appear for their case. So that is a fix for that, and we fully support that. That's my testimony. I'll be happy to answer any questions. Thank you.
Thank you for your testimony.
Good morning, Mr. Chairman, Mr. Vice Chairman, distinguished members of this committee. My name is Charlie Maloff. I am the Vice President for Texas Cure, and we're all for this bill. We're all for tough on crime, but we're also, in the interest of justice, we're also for fundamental fairness. What I have is in line with Senator Huffman's comments about the intent of the bill, and this is a real-time situation that I think needs to be addressed. I have a Dallas County jail inmate, Robert Harris, who was arrested in April of 2019. He was bonded out in June of 2020. During his release, he was monitored with an ankle bracelet and fulfilling his obligations of employment and attending college and supporting his wife and children. On September 25th, 2021, he missed a court date, having arrived at the courthouse, but with work tools that prohibited his entry. He contacted his lawyer at the front door of the courthouse and informed him of the issue, and the court date was rescheduled. Harris was not informed by his attorney of the changes. Subsequently, he was apprehended by warrant on December of 2021. He was rebonded out January of 22, but the bond was held insufficient. But later in 2023, he was approved for work release. He was court-appointed. His original attorney was then arrested on unrelated charges, and then he was assigned a court-appointed attorney, Paul Johnson, who is subsequently assigned to this case but refuses to respond to the client. As a result, Harris has now filed motions to appear pro se, which has been ignored. He subsequently filed for relief in federal court, only to be challenged with a notice of deficiency in order. This deficiency is due to his being denied access to the law library and to get necessary assistance for a proper pleading. As of right now, he still remains in Dallas County Jail, kind of lost in the system. He continues to sit in jail without access to his legal counsel, effectively forgotten by the system. Efforts to rectify his situation are ongoing, and Harris seeks to file a writ of habeas corpus. This case reflects the significant concerns regarding access to legal representation, egregious neglect and irresponsibility of a significant number of court-appointed attorneys, fundamental fairness, and violates the spirit and intent of the constitutional rights and the integrity of this process. Thank you.
My name is Steven Huerta, and I'm with all of us from Nunn, Texas. And today I speak not in opposition for the sake of opposition, but in defense of the corporate conservative principles that I strongly believe in: limited government, fiscal responsibility, and individual liberty. Senate Bill 9 is being presented as a measure for public safety, but the reality is far different. The bill does not make us safer. It makes our system more costly, less fair, and more intrusive. First, let's talk about local decision-making and fairness. SB 9 takes away the ability of judges who know their communities best to make the case-by-case bail decisions. Instead of allowing judges to consider the facts, this bill enforces blanket rules that will keep people in jail simply because they cannot afford bail. That's not justice. It's punishment before trial, regardless of whether a person is actually guilty or possesses any kind of risk to public safety. Second, let's talk about fiscal responsibility. Right now, more than 70% of Texans in jails have not been convicted of a crime. They are simply awaiting trial. Keeping them behind bars costs taxpayers $1.2 billion a year, and this bill will only drive those costs higher, forcing counties to expand jails, draining resources that could be better spent on real public safety solutions. Finally, let's talk about basic rights and fairness. SB 9 would allow prosecutors to appeal bail decisions, forcing people to remain in jail even after a judge says they should be released. This means that someone presumed innocent could be sitting in jail for months, losing their jobs, their homes, their ability to care for their families, all without a conviction. Our legal system is built on the idea that people are innocent until proven guilty, not the other way around. This bill does not protect communities. It expands government power, increases taxpayers' costs, and takes away from the local judiciary. It creates a system where wealth determines freedom, not fairness or safety. I urge you to take a hard look at the consequences of Senate Bill 9 and ask, is this in line with our conservative values? It's not. It increases government. Thank you.
Thank you all for coming. Chair calls Nick Hudson, Matt Makoviak, J.R. Woolley, and Kirsten Budwine. Kirsten Budwine. Is Kirsten Budwine here? Kirsten Budwine?
She's in the overflow rooms.
Is Kirsten Budwine? We'll start on my right. State your name and what your position is.
Before I begin, is this testimony on all of the bills combined?
I'm going
One at a time?
That way everyone will get a chance to speak on each one.
Great, thank you very much. Thank you, Mr. Chairman. My name is Nick Hudson. I'm here on behalf of the ACLU of Texas in opposition to SB 9 because it undermines due process, the presumption of innocence, and judicial discretion. It would keep more Texans in jail not because they are dangerous, but because they are poor. First, it allows prosecutors to unilaterally prolong pretrial detention by appealing bond decisions and keeping people in jail during the pendency of that appeal. That is too much power to give prosecutors in our state.
Could you move your mic just a little bit?
Yes, please. Thank you.
We want to hear you.
Thank you. Second, SB 9 expands restrictions on personal bonds to broad categories of offenses, including some misdemeanors. And this blanket approach removes judges' ability to assess risk and ensure fair outcomes. One example is terroristic threat, a charge often that constitutes an empty threat and often is used in school-related cases where there's no real public safety risk. Judges already have discretion to deny personal bonds when necessary. SB 9 would force them to set money bail in all of these cases. And together, both of those provisions would impose an absolute bar on release to people who have no money in our state or are too poor to afford the bail amount, while allowing identically situated people with money to purchase their freedom. Finally, SB 9 bars criminal law hearing magistrates from setting bail in certain cases and restricts which judges can modify bond amounts. These officers handle many, many cases each year, ensuring timely hearings and preventing unnecessarily lengthy jail stays. Limiting their role will create harmful delays, infringe on due process, and result in longer pretrial detention for people who could otherwise be safely released. Thank you.
Thank you for your testimony.
Good morning, Chairman and members. I'm Judge J.R. Woolley. I'm the Justice of Peace in Waller County, and I'm here on behalf of the Justice of Peace and Constables Association on Senate Bill 9. I'm going to read some of the canons that we go by as judges. An independent, honorable judiciary is indispensable to justice in our society. A judge should personally observe those standards so that the integrity and independence of the judiciary is preserved. A judge shall comply with the law and should act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. The judiciary, one of the tenets of our foundation and our society, is that our judiciary is independent. There's been some changes from the original bill to the committee substitute, and we talked to Senator Huffman's office about it and made those changes. We're actually okay with those changes as they stand now, but I do want to make sure that it's known that if the legislature removes the impartiality of judges, that's a detriment to our society. The second part that I'd like to talk about is there's on page 11, line 7, there's a word modify. We would like to see that changed to reduce. As Judge Ligon, or as DA Ligon said, he sits next to Harris County, as do I. This says that if a district judge sets a bond, we can't modify it. I see Harris County warrants with $100 bonds. If that person has a theft bond and $100 is sufficient for that, but when they come to Waller County, they run from the police and they fight the police. Who else said that? Oh, Andy Kahn said that, give us discretion. Let us increase that bond. This person's a threat to society. We should be able to increase it. I'm okay not reducing it, but to change that modify to reduce, I think is very important. As Senator King said, to err on the side of public safety. Let's err on the side of public safety and let us as the magistrates, seeing these people, raise that bond on that original charge. I know there's going to be other charges, but protection of society is extremely important.
Thank you, Your Honor. Thank you for your testimony. Please proceed.
Greetings, Chairman and committee members. My name is Kirsten Budwine, and I'm a policy attorney at the Texas Civil Rights Project, and we are opposed to SB 9. Thank you for allowing me to provide testimony on this bill. Community safety is paramount to our mission, but our current pretrial system is counterproductive to that point. As Senator Huffman said, Section 7 of this bill builds on the personal bond restrictions that were imposed by SB 6. SB 6 limited judges' abilities to grant personal bonds in cases where the accused was charged with one of the enumerated offenses, including some misdemeanors, if they were released on bail or community supervision for an offense involving violence. As a result of SB 6, counties across Texas saw a sharp uptick in jail populations, where the total jail population rose by almost 7%, with some counties seeing a much bigger increase. We are bound to see similar but more drastic results under SB 9 if this becomes a law, because SB 9 casts the net much wider by prohibiting personal bonds for people simply charged with any of the enumerated offenses. As it relates to Section 8, prosecutors are one of the most powerful figures in our legal system. Expanding their powers to allow them to appeal a bail order when they subjectively think the amount is insufficient and effectively keeping people in jail while the appeal is pending is extremely troubling. The tool would effectively override a judge's statutory duty to impose the least restrictive conditions and bond necessary, and give prosecutors the unilateral power to hold people in jail for long periods of time anytime they think a bail amount is insufficient. It is worth noting that prosecutors already have the power to challenge bail amounts by filing a motion for sufficient bail and asking the judge or the magistrate to enter a sufficient bail pursuant to Articles 17093 and 1715 of the Texas Code of Criminal Procedure. For these reasons, we are opposed to SB 9. Thank you.
Thank you very much for your comments.
My name is Matt Makoviak. I'm here on behalf of Save Austin Now. Save Austin Now is the largest grassroots organization in the history of Austin, and we are committed to improving public safety. While there's been a justifiable focus on Harris County and some of the outrageous decisions that have occurred there that have harmed public safety in this hearing with the leadership of Senator Huffman, I want to make sure you also understand how critical Senate Bill 9 is to the residents of Travis County. And I know that county matters to all of you as you all work here part of the year, and your staff works here more so than even maybe you do. We have a district attorney in our county here who is not committed to improving public safety, period, full stop. He is doing many of the things that this bill would directly address, but he is doing them actually at a much higher level, affecting far larger number of violent criminals, releasing them, reducing bonds, zero bonds, PR bonds, unnecessary delays that take people to the end so that indigent people then get released. The reason crime is going up in Austin is because habitual offenders are not being treated seriously by our district attorney and by the judicial system here in Travis County. And this bill, in a very thoughtful, very intelligent, very strategic way, takes on the absolute most ridiculous parts of this system currently. It is very clever the way it has been devised. It is very reasonable. The Senate deserves commendation, as does Lieutenant Governor Patrick, for taking on this issue previously. It is outrageous that the Texas House has not moved bail reform bills the last two sessions. And I am committing to you today, if the Senate, particularly on a bipartisan basis, takes this action, we will bring many violent crime victim witnesses to the Texas House to ensure this bill gets fair and serious consideration and moves this session. So I want to thank the chairman, I want to thank Lieutenant Governor, the governor, Senator Huffman, all of you. Every single crime that has been talked about today was preventable. And so without action, we're going to continue to have preventable violent crimes committed in our state. It should enrage every member of the legislature that this is happening in our state. Thank you very much.
Thank you for your testimony. Members, any questions? Thank you very much. Thank you for being here.
Thank you. Thank you all for being here.
Chair calls Goldie Van Zant, Kim Nesbitt, and Amal Sharif. We'll begin on my right. You have 2 minutes. Please state your name and your position.
Good morning, Chair Flores and committee members. My name is Kim Nesbitt. Thank you. Sorry. My name is Kim Nesbitt, and I'm Chief of the Pretrial Bond Division in the Dallas County District Attorney's Office. I'm here representing my boss, John Crusoe, in support of the committee substitute for SB 9, specifically because this bill begins to correct the ruling in ex parte clear. That doctrine hampers us greatly. Thank you, Senator Huffman, for continuing to improve the bill process and working with us on this particular issue. Dallas County takes a lot of guff for bond issues, but we are severely impacted and affected by ex parte clear. A clear county is what I'll call it, is where municipal judges set bonds in municipal jails, and then they retain jurisdiction over that bond and the bond conditions until that case becomes pending in the court where it will ultimately be heard. Pending means that the case has been indicted or the information has been issued. In Dallas County, we have over 28 municipalities. We had a situation where a defendant committed multiple family violence, misdemeanors, and felonies over the course of 4 months. He was magistrated at the municipal level and bonded out each time. The last offense he committed occurred before the first case was even filed with our office, let alone indicted. Since there is no line of sight between municipalities and the court of ultimate jurisdiction, we cannot legally address these serious safety concerns until there is an indictment or an information filed. Committee substitute to SB 9 creates a legal remedy for prosecutors to file a motion before a court of ultimate jurisdiction, and it allows us to request access to the PSRS to see what conditions, if any, are already in place. We are very grateful for these additions and believe they will make a difference. We understand that there are more conversations to be had on this issue, and going forward, we would ask that misdemeanor DWI, family violence, and terroristic threat offenses also be included because they encompass behaviors that escalate quickly, as you heard earlier, to higher offenses and impact the safety of every citizen. We also ask the bill to define the word pending because the judicial interpretation of pending is the period of time after indictment or information is filed. Bail issues can arise at any time prior to the indictment or information with devastating consequences. Again, thank you for your monumental advancements in SB 9, and we look forward to working with you as this process continues.
Thank you. Thank you for your testimony.
Thank you.
Good morning, Chair Flores and community members. My name is Goldie Van Zandt, and I'm a U.S. Navy veteran. I have two bills to speak on. Could I go just a little bit longer than 2 minutes?
Oh, you speak on this bill, Senate Bill 9. We'll do the others individually.
Okay.
So that way everybody get a fair chance to talk about each bill. But
All right, thank you.
Please proceed.
All right.
Senate Bill 9.
All right, thank you. My husband was a disabled Navy veteran who was honorably discharged in 2002 after 20 years of service. My husband was a staunch Republican, and I am a Democrat. But we were happily married for 40 years and ran a bipartisan household. In a home that we owned in Houston, together we raised 3 wonderful and successful children and 4 grandkids. My husband was on the USS Enterprise during 9/11. He fought for this country because he passionately believed in the values of freedom and liberty. freedom and liberty that was ultimately denied to him in his own life over and over again as he battled PTSD, depression, and substance use disorder. Since 2019, he was repeatedly criminalized for his mental health, incarcerated in Harris County Jail, and held on high cash bail. He would be alive today had it not been for the physical and mental abuse he was subjected to during his lengthy pretrial detention the first couple of times. I am here today and speak in opposition to SB 9 because the standards of detention was already way too low. The bill will further lower the bar and disproportionately impact people like my husband who often face felony charges that are the result of their mental health crisis. This bill would lead to more people being jailed before trial for bad reasons. It lacks necessary safeguards and undermines fundamental rights. I've been working with Texas Jail Project as an advocate and a navigator for veterans held pre-trial in county jails across the state. Pre-trial population in county jails spiked sharply after SB 6 was passed, causing immense harm and custody deaths. Last year, as per the Texas Commission on Jail Standards, 135 people died in custody in our county jails.
Thank you for your testimony. Ms. Sharif?
Good morning, committee members. My name is Amal Sharif. My condolences go out to all the families here who have lost their loved ones due to a crime. I want to take a moment to share with this committee the other victims who you may never hear about. Last year, as data collected per the Texas Commission on Jail Standards, 135 people died in custody in our county jails, a large majority of whom were pre-trial, meaning they were legally innocent. In Harris County, we have had over 85 deaths, custody deaths since 2021. One of them was 31-year-old Evan Lee. He was a special needs person. He was a kind young man and a hard worker. Evan spent time in a psychiatric facility. He was arrested because his ankle monitor was malfunctioning. Despite alerting the county multiple times in the court systems about the malfunction, he was locked up on $25,000 cash bail. He ended up being murdered whilst in custody. He was never even considered a victim. Another one of those deaths was 19-year-old Fred Harris, who was also a special needs individual. His death was ruled a homicide as well. His family are not counted as victims or as survivors. Another person was 38-year-old Kristen Smith, a loving mother, a daughter with no criminal history, who died in pretrial detention while being held on an aggravated assault charge. Her crime was that she defended her special needs son from a violent person. One of the most recent deaths we had in Harris County a few weeks ago was 29-year-old Christopher McGregor, who was held on a theft charge. His family had still not been allowed access to his own body. We have had 3 people die in LaSalle Corrections Facility as pretrial detention after they were shipped out to Louisiana from Harris County. I can go on and on about the hundreds of victims who are never counted as victims, who were given de facto death sentence during their pretrial. I urge this committee and to count all these people who died in custody when considering public safety. Thank you.
Thank you for your testimony. Thank you all very much. Is there anyone else that would like to testify for, on, or against committee substitute for Senate Bill 9? Hearing none, public testimony is closed. The chair now opens public testimony on Senate Bill 1047. Chair calls John Wilkerson, Luz Dove, and Andy Kahn. John Wilkerson, Luz Dove, and Andy Kahn. Okay, go to the next one. Chair calls Aaron Johnson, Kim Nesbitt, and Columba Wilson. Aaron Johnson, Kim Nesbitt, and Columba Wilson. And if you have 2 minutes, state your name and your position.
Yeah, I said, good morning, Chairman Committee. Thank you for allowing me to speak. And I'm sorry about my accent. I have two grandkids that they have their special needs. And one of them, his mother was using drugs, and there was drugs involved. So they were getting into fights, and Mama would always call the police, always call the police. So he was sitting out of jail for probably 3 years, and the last time in Bastrop, he was there for probably 6 months, because the bail bond, that was in 2022, the bail bond was $135,000, and I could not afford to pay that. So by the time he went to court, I was allowed to speak to the judge, the wonderful judge. And like I said, my answer is not yes or it's no. There's always history. So he lowered the bail bond from $135 to $1. So he said, he's going to go and you're going to take care of him. You're going to be responsible for him. And I said, okay. So he was doing very good, working at McDonald's, fantastic, no drugs, no nothing. And the last February, in the 18th, he had an episode. He broke the window in the Via bus with his head. So blood and everything, they put him in jail. His IDD, maybe like a 65 IQ, cannot really finish school. And he was a victim of society, a victim of the police. He was victimized by everybody. So anyway, so I was just looking at this bill. I don't understand very well. But I don't think that judges should put people like this in jail because they need help. They don't need to go to jail and be raped. And the same thing happened with my 20-year-old grandson that's autistic, has a man of a 3-year-old. He broke a window in the house of a woman. He was at a group home. So he escaped. He broke a window of the lady, and her son-in-law was Bobby Barrera. So he decided that he was going to make an example out of my grandson, and he put him in jail for 21 days, and they didn't allow me to get him out. Well, thank you so much. Nice to see you, Senator Parker. Senator Hinojos, I'm sorry.
I hear a phone ringing, but I can't find it. Anyway, so let me just say that in many jurisdictions, they do look at people that have mental health issues. They don't do that. They don't put them in jail. So but it's spotty. In many areas they do. In many areas they don't have the process to inspect them and talk to them and find out what the situation, the mental situation.
No, but he was in San Antonio. No, I understand that. It's just ridiculous that they grab a boy with a man of a 3-year-old. I saw the police grab him and they throw him in that dirt and the cement. And who do you think they are? They're not God. I'm sorry. I just get so upset. So then the guy right now is assistant living center, and that's one problem that we have. We do not have any place to get help for kids with mental illness. There is no place. They're not crazy. They just have mentally challenged.
And try to fix that.
Yes, I thank you so very much. Appreciate it. Thank you.
Aaron Johnson again for the Texas Association of Pretrial Services. I just want to point out a couple of things that I forgot for the previous, but it relates to this as well, is that these bills are just being proposed, and you already have people here trying to widen the net of who should be held and who shouldn't, and under what conditions they should be released. In Senate Bill 1047, the first issue that kind of comes up is that in Section 2, it's talking about having the PSRS provided, and as soon as practicable, but not less than 48 hours, defendant's arrest, the magistrate, the attorney representing the state, and the clerk of the court, in which the case is pending, to be able to make those decisions. I would also advise that the individual has rights as well. There should be some type of attorney representing the individual during this process as well. We've seen in multiple jurisdictions, I believe Travis County is currently under being sued because they're not providing counsel at these hearings. The other part is specifically talking about if they're charged. There's been multiple examples given of prior to the change to 17027, which talks about people that already are out on bond and have these cases and what judges and who gets to set bond and things like that. A lot of the examples, as bad as they are, were prior to a lot of the new laws going into effect. And so I want to make sure that we're talking about apples to apples and not things that have occurred prior to current legislation. Because a lot of what 1047 and 9 are talking about, they're already fixes for that in the current legislation. So I would suggest to really look at what you're trying to do versus what is already on the books and should be being followed. So,
Thank you for your testimony. So is there anyone else who'd like to testify for, on, or against Senate Bill 1047? Hearing none, public testimony is closed. The chair calls the following, the chair now opens public testimony on Senate Bill 40. Chair calls the following witnesses: Aaron Johnson and Nate Walker.
I can just stay.
Again, please identify yourself for the record, speaking to the microphone. You're limited to 2 minutes for each bill, subject to the discretion of the chair. We'll start on my right.
Hi, Mr. Chairman and Senators. My name is Nate Walker. I represent the Bail Project. We are in opposition to SB 40. The Bail Project is a national nonprofit organization that provides cash bail assistance to low-income people across the country. Between 2018 and 2023, we provided free bail assistance to almost 1,400 Texans who returned to nearly 90% of their court dates. What our work shows us is that the Texas pretrial and cash bail systems are broken. We cannot agree more that we need to focus on public safety, but this bill does not accomplish that. I'm here to correct the record and assure this committee that the Bail Project does not accept public funds or taxpayer dollars in Texas. The auditing documents discussed today reflect our own money coming back to us when our clients' cases close. I repeat, the Bail Project does not and never has accepted public funds in Texas. The payments mentioned are reimbursements when client cases resolve. I will be by each of your offices with documentation to clarify this. Thank you for your time.
Thank you for your testimony. Mr. Johnson.
Yes, sir. Aaron Johnson, TAPS. Again, I think in regards to a lot of what we're discussing today, there are a lot of people who are either misinformed or are not aware of how the process actually works, about how long it takes for a case to actually come in front of a jurisdictional judge for first-time offenses. Again, 17027 already talks about when a judge has jurisdiction and who's supposed to be setting bonds on those cases. In regards specifically to Senate Bill 40, is there ever any evidence that this has occurred? I am well aware, and my individual here on my left, aware of the social media misinformation that's gone out in regards to this process and what they think they found. But in anyone who posts the entire amount, you're going to get a receipt saying you've paid this minus whatever court costs are accrued. Now, most people aren't aware of that because that is not what happens. Most people are very familiar with the bonding process and about 10%, 15%, whatever that is. Again, I urge you to consider going back and looking at all the time you are spending regarding amounts of money. Remove money from the system. You don't have 90% of the issues that we are trying to discuss and figure out ways to get around today. Thank you.
Thank you for your testimony. Thank you. Is there anyone else that'd like to testify for, on, or against Senate Bill 40? Hearing none, public testimony is closed. The chair now opens public testimony on committee substitute for Senate Joint Resolution 1. So the chair calls the following witnesses: to come forward. Please, when you come forward, identify yourself for the record, speaking to the microphone. You will be limited to 2 minutes and subject to the discretion of the chair. If you have any written testimony, please submit the copies to the committee staff to the desk to the right. So the chair calls Ammon Blair, Aaron Johnson, Ken Good, and Emily Anaya. Ammon Blair, Aaron Johnson, Ken Good, and Emily Anaya. We'll begin on my right. Please state your name and your position, and put the microphone close so we can hear you.
Good morning, Mr. Chairman. Good morning, committee members. My name is Emily Anaya. I'm a second-year law student at the University of Texas, and I'm the daughter of a Mexican immigrant. I believe that protecting victims of violent crime is absolutely critical. That being said, I'm here today in opposition of SJR 1, and I have 3 reasons for your consideration. First, SJR 1 violates the Equal Protection Clause of the United States Constitution. Both immigration status and national origin are protected classes entitled to equal protection under the law. Thus, this resolution contradicts one of the most treasured constitutional rights and would invite further abuse of equal protection in Texas. Second, SJR 1 is suspect as a proposed amendment because it would contradict the construction of the Texas Constitution's Bill of Rights as it pertains to bail. The current restrictions on bail all go to the criminal actions of the defendant, not their personal characteristics. Rather than narrowing the eligibility of bail on a similar basis to those already listed in the Texas Constitution, this amendment would target a protected class. Finally, SJR 1 is not based on any realistic interpretation of crime data in the state of Texas. The data show that undocumented immigrants commit felonies at a lower rate than U.S. citizens. Therefore, if the purpose of SJR 1 is to protect victims of crime, more individuals would be protected by preventing U.S. citizens charged with felonies from posting bail, rather than to strip this right from undocumented people only. The proposed bill would serve to expedite the incarceration of undocumented people charged with felonies and erode procedural protections for Texans on the basis of their immigration status, which is unconstitutional. Mr. Chairman and committee members, protecting Texans from violent crime through bail reform should be enacted across the board rather than encroaching upon the Equal Protection Clause. Thank you for your time.
Thank you for your testimony. Please proceed.
All right, good morning, Chairman Flores, Vice Chair Parker, and distinguished members of the committee. My name is Ammon Blair. I'm a senior fellow at the Texas Public Policy Foundation, and I'm here before you today in strong support of SJR 1. The constitutional validity of this amendment rests on 4 fundamental principles: the distinct legal status of citizenship, state sovereignty in immigration matters, Texas's retained power of self-defense, and established precedent regarding differential bail treatment. Supreme Court jurisprudence has consistently held that illegal aliens do not qualify as, quote-unquote, the people under our Constitution. The court has defined the people as those who are part of a national community or who have otherwise developed sufficient connection with this country to be considered part of that community. The 14th Amendment explicitly establishes that citizenship requires not just presence, but being subject to the jurisdiction thereof. As the Fifth Circuit recently reaffirmed, illegal aliens are not, quote-unquote, law-abiding, responsible citizens or, quote, members of the political community. Also, our Constitution recognizes states' inherent sovereign authority in immigration matters. Our nation's structure as a union of sovereign states works in concert with the Declaration's recognition of states' authority to do all acts and things which independent states may of right do. The Supreme Court has recognized states' fundamental power to forbid the entrance of foreigners with its dominions or to admit them only in such cases and upon such conditions as it may see fit to prescribe. While Article 1, Section 8, Clause 10 grants Congress the authority to control immigration, this power is not exclusive to the federal government. According to Article 1, Section 9, Clause 1. Even Arizona versus United States limited the federal government's exclusive authority only in the field of alien registration, preserving states' concurrent power in all other domains. The Supreme Court's bail jurisprudence also supports this framework. The court held the 8th Amendment says nothing about bail shall be available to all.
Thank you for your testimony. Thank you for being here.
Aaron Johnson, Texas Association of Pretrial Services. In regards to this bill, in regards to the amendment that would be proposed I think the language, in conversation that we've had, I think the language is overly broad. There is a real sense of people not understanding risk, public safety risk, versus what a misdemeanor and a felony is. I think people look at that on its face and they think, oh, felonies are public safety issues and misdemeanors are public nuisance issues. While they may be coded that way, that is absolutely not the correct way to look at what public safety and how those should be assessed actually is. My question here is, what's the resolution when this person is either not filed, no charges brought, and/or is not the right person? What's the relief? Because in this amendment, there is no what happens after the fact. It just says that bail is denied. There's no relief factor, which we are all, as part of the following the rule of law. I get due process when I'm held. This is not ancient medieval England. You don't throw people in a tower just because you don't like them and/or they're not following a specific rule. Due process exists for everyone under the law. So, thank you.
Thank you for your testimony. Thank you. Chair now calls Virginia Raymond.
Follow-up question, please.
Question.
Yeah, Mr. Blair? Is it Mr. Blair?
Yes, sir.
Yeah. Ms. Nye testified that she believed that this would violate the Equal Protection Clause, and also that it would target a protected class. Do you agree with that?
No, sir.
Why not?
Because if you look at the term of the Constitution, in the Constitution of the people does not represent illegal aliens inside the United States. As recently as the Fifth Circuit Court. Now, that court's decision was based off of the Second Amendment in regards to whether illegal aliens had the right to bear arms. However, that court's decision was also on the other cases, if you can see in my packet that I gave you, in regards to other cases involved not just the Second Amendment. So the Constitution itself limits the protection of these liberties to citizens of this country, not so much illegal aliens.
So we're not targeting with this bill a protected class. It's just talking about people who violate the law by coming into the country illegally.
Yes, sir.
Thank you.
Thank you. Any more questions, members? Thank you all very much. Thank you for being here. Chair calls Virginia Raymond, Michael Mireles, Sarah Cruz, and Danny Woodward. Virginia Raymond, Michael Mireles, Sarah Cruz, and Danny Woodward. Begin on my right. You can state your name and your position, and you have 2 minutes.
Chair, my name is, and Senators, my name is Virginia Raymond, and I'm here on behalf of the Lone Star Defender's Office to testify on SJR1. Lone Star Defenders is the hub for indigent representation of people arrested in Operation Lone Star. Since 2021, our office has coordinated the representation for over 4,400 defendants charged with felonies, primarily smuggling of persons, and approximately 75% of those people are U.S. citizens. I will address our three primary concerns, and there are other issues noted in my written testimony. One, the bill radically disturbs the careful balance protected in the Texas Constitution. Presumption of innocence is not just a phrase. Liberty is more than a word. Bail represents a compromise between our insistence on the presumption of innocence and its corollary, making sure we do not wrongfully deprive anyone of liberty, and the need to make sure that people show up for trial. Every person charged with crime in the United States is presumed innocent unless proven guilty. We restrict liberty only when and to the extent necessary to ensure that people show up for trial and to protect public safety. That is why bail is protected by Article 1 of the Texas Constitution as well as by the Code of Criminal Procedure. The power to require bail is not to be used to make bail an instrument of oppression. This bill, the resolution radically alters the careful balancing of those interests. We are concerned that it would wrongfully, unnecessarily deprive people who are entitled to the presumption of innocence, and it would do so while making no contribution to public safety. Two, the bill is unnecessary. Judges are already empowered to set bail at an amount that ensures people will make every effort to show up for their court proceedings. Judges can do this. For instance, most Operation Lone Star clients charged with felonies are unable to post bond because the average bond is $85,000. There's no need to change the Constitution to preclude bail since people cannot pay those bonds anyway. And as a factual matter, most of those are U.S. citizens. Fine. Thank you.
Yes, thank you, Chairman Flores and the committee for the opportunity to provide testimony. Oh,
I'm sorry.
sorry. Could hear myself. Yes. Thank you, Chairman Flores and the committee for the opportunity to provide testimony. My name is Sarah Cruz, and I'm a Border and Immigrant Rights Strategist with the ACLU of Texas, here to share our opposition on SJR 1. SJR 1 proposes to amend the state constitution by requiring judges to deny bail to all individuals who meet the bill's definition of an illegal alien if they are accused of a felony offense. The blanket application of denial of bail based on immigration status would force potentially thousands of people, including U.S. citizens, to remain incarcerated in pretrial detention with no consideration on the likelihood of their guilt. We strongly urge this committee to oppose SJR 1 as it would violate the constitutional right to due process, detain individuals who may pose no risk to public safety or may otherwise be eligible federal relief, and raises concerns on forcing state judges with no authority or expertise in immigration law to make status determinations. SJR 1 also offers no exceptions for any individuals who may be a victim of crime or human trafficking. Reminder, SJR 1 violates an individual's constitutional right to due process. The blanket application of SJR 1 based on immigration status would deny individuals the opportunity of an individualized bail hearing. Any attempts to deny bail automatically without any consideration of the likelihood that the suspect is guilty of the underlying offense would be unconstitutional. The importance of individualized bail hearings has been emphasized by numerous court decisions, including United States versus Salerno. SJR 1 also provides no protections for exceptions for individuals of crime or human trafficking or those eligible for federal relief. Under the bill's broad definition of an illegal alien, individuals, including U.S. citizens, who are still only accused of a crime may be a victim of human trafficking, victim of another crime, or may be eligible for other federal protections, would have no opportunity to apply for relief under SJR 1. Lastly, SJR 1 would also force state judges who have no authority or expertise in immigration law to make those status determinations. Granting this authority to individuals with no expertise in immigration law could potentially lead to wrongful pretrial incarceration of someone who may be innocent. Requiring state judges to make these determinations, paired with the bill's broad interpretation of an illegal alien, will also likely result in the loss of freedom for U.S. citizens, naturalized citizens, and individuals who may have other type of lawful status.
Your name and your position, please proceed.
Good morning, Senators. My name is Michael Mireles. I'm a member of La Unión del Pueblo Entero, Lupe, and I'm also a resident of Hidalgo County. Before I read my prepared remarks, I just wanted to say, Senator Hinojosa, that I'm a bit disappointed in your choice of words about the border. It is known that border communities have lower violent crime rates than non-border communities. My first issue with this joint resolution is its definition of an unauthorized immigrant, specifically someone who has entered the United States without inspection. There are many people, including naturalized U.S. citizens, who would meet this definition. My second issue with SJR 1 is the determination of someone's legal status as they enter the court system. Who will be making this determination? Who will be verifying that someone meets the conditions of this proposed constitutional amendment pre-trial? The potential for misidentifying a person's immigration status is too easy, and thus the risk is too high. I understand the need for bail reform, but SJR 1 is not bail reform. It doesn't even address violent crime in its language. This is a biased, misguided attempt to keep non-dangerous people behind bars, and I urge people to look closely at the purpose of this resolution. Thank you.
Thank you for your testimony.
Good morning, Danny Woodward with the Texas Civil Rights Project. Excuse me. And here's my written testimony. So I work with the Beyond Borders program with the Texas Civil Rights Project, and I'm a policy attorney. And I want to start by acknowledging the real and deep pain that the victims that we heard from earlier today have experienced. For the past 30 years, TCRP has worked closely with border and immigrant communities across the state to ensure they have fair and equal access to justice. And it is this experience that leads us to oppose SJR 1. We oppose treating people differently based solely on their immigration status. The Supreme Court has stated that a person can only be denied bail if they pose a identified and articulable threat to an individual or community. Immigration status is not evidence of such a threat. Furthermore, the complexity of federal immigration law will make it very difficult for state judges and prosecutors to administer the requirements of SJR 1. When a person is arrested, the state authorities may receive some information about that person's immigration status from a government database. They may receive nothing, and even more confusingly, the definition of the amendment will wrap up people with valid immigration status and even U.S. citizenship. The proposed amendment is silent to the proper procedure if immigration status is unclear. Will prosecutors or judges have any training on immigration law? Will a person be able to contest the determination about their status? What standard should a judge apply when determining whether a person meets the definition of a legal alien under the amendment? And what should happen if the government claims that a person entered the country without inspection 30 years ago, but the person shows a document proving they are now a U.S. citizen? In short, the amendment is likely to create a procedural headache that will only further gum up our already overburdened courts. And in addition to burdening our courts, SJR 1 will balloon the already unwieldy population of Texas jails and require local governments to spend their stretched resources building new facilities and hiring new people. Thank you for your time today.
Thank you very much. Thank you for your testimony.